cases, madam. One is from Nunmat, other is from Karbi Anwar.
These are bail applications?
Yes, madam.
Oh.
15 and 16. I am for item number 16, madam.
15.
That may not be tagged together, madam. And I adjourn the matter, item number 16, madam.
Acha. So you want to do 15 today?
Yes, yes.
Case diary is there.
And the CD not received, my lord, item number.
Oh, so 15.
Yes,
It is not tagged.
it is tagged.
15, 16.
Yes, yes, madam.
It is not tagged. Otherwise, it's not shown in the cause list.
But
My lord,
it
which
was,
is there, my lord.
Huh?
15 and 16, my lord, there is a cause this, my lord, which is there, my
yeah,
What
with
a wheat. Which code? I don't.
and they are
Oh,
put
in
together
my
as a
list, it
record.
is not shown with
Yes, madam.
15, 16. Plabita and Abdul Malik.
Now 15 is Sajid Ali.
Uh-huh.
And
It is
six-
এখন কি?
16 is Deepak Kumar.
Thursday.
I am for Deepak Kumar. Bhatt.
Thursday don't. Acha, I'm holding a Thursday's list. Okay, yes. 15, 16, yes. Sajid Ali and Deepak Kumar.
I want to adjourn Deepak Kumar. Bhatt.
And then otherwise, case diary is also not there, miss.
There.
For 15, whether case diary is there for
No,
15.
no.
The date.
That will be a same case diary or
No, my
separate?
lord, different, my lord.
Different.
Item number 15 is from Nunmati police station, my lord.
Hmm.
Item number 16 is, it is from my lord.
Acha.
Karbi Anwar.
Karbi Anwar.
Why is it tagged?
Mistakenly.
Some mistake.
Mistakenly.
But my lord,
Okay.
in the order of 16, my lord, it may be tagged with another, my lord, matter 1399/2026.
Oh, the wrong application is tagged.
As per-
Just show me, Hemenda song 15, 16. Song ke liye tag hole. Yes. Yeah, please. हाँ, ठीक. Hmm. 16, you write. Mr. D. Vora, learned counsel for the petitioner, seeks an adjournment and prays that the matter may be taken up when?
Immediate, madam.
May be taken up next week.
Next week.
Accordingly, not like accordingly, next week, Mr. K. Bosha, learned APP also submits that the case diary in connection with the said case is not received. And he also has prayed for some time. Prayers are allowed. List this matter on list this matter on next Friday, 19th of June.
Okay.
Okay. Oh, your matter is still there. So 15 to?
15.
Acha, this is 15, right? 15, 16. Ouch. No, why was it tagged? I wanted to see this. There is no tagging order in 15. Let's see 16.
15, my lord, 8/6/2026, maybe some order may be there.
Oh, wow. What is the date you said?
8/6/2026.
8-6 is not there. 5-6 is there. No formal stay. Rooted true. Is it item number 16 is a POXO matter?
Taxometer, madam.
Oh, that is why notices are. But then there is no tagging order, Mr. Counsel.
That, my lord,
There might be
my
some
lord,
mistaken, madam.
Okay. তাৰপিছত দিয়া আকৌ দিয়া তাতে, huh? It is also noticed that the instant bail application is tagged along with another bail application being 1466 of 2026. However, on checking the order sheets, it is found that there is no order for tagging the said matters. As such, the present application is detached from the other application, that is 1466 of 2026, and the same may be heard independently. So 16 is over, huh? 15, 15 or due, 15, Miss P. Das, learned counsel for the petitioner, heard Miss P. Das, also heard Mr. K. Bosha. Mr. Bosha submits that the case diary is not available and has prayed for some time. Prayer is allowed. In this petition, it is also noticed that the same is tagged along with another bail application being 1456 of 2026 without there being any tagging order in both the applications. As such, this application is detached from the bail application number 1456 of 2026. The matter should be taken up independently. List this matter on
Next.
22nd of June.
Deeply.
May I please?
Yeah,
Victim is item number 3 orders.
3.
Kindly
I'll
pass out-
take up bail matters first, huh? Then I'll go to this criminal matters. Item number 3,
Yes.
yes?
Madam, next week, your lordship.
Okay. As prayed for by Mr. S. Islam, learned counsel for the petitioner, list this matter on 23rd of June. 23rd. Yeah, Miss Brown, you are there.
Yes, your lordship.
Yesterday, I had appointed you as an amicus curiae in some matter. You'll get the notice.
Yes, your lordship.
Mr. M.K. Brown is also present, huh? Didva.
May I please,
Yes.
your lordship? Should I beg to mention item number 35 of the supplementary list?
35, yes.
Should you kindly allow me to withdraw this petition, lordship?
Okay.
Lordship, I have to annex certain more documents, lordship, including the
Oh,
school
is it?
certificate.
I thought you got bail somewhere.
No, lordship. During the pendency of this petition, I cannot move any bail petition.
Oh, yes, of
I will
course.
file a fresh, lordship.
Uh,
Only that
Mr.
School certificate.
Mr. M. Ahmed, learned counsel for the petitioner submits that he has instructions to withdraw the matter. The prayer is allowed with the prayer is allowed with the liberty that the petitioner may file any fresh application after any fresh application.
I have, lordship. Another prayer is that, lordship, item number 8. Lordship, may kindly pass over the matter for detail, lordship.
8,
After a week, lordship.
item 8,
Eight.
because there is there.
And
But
the
it's
stamp
TPR.
is here,
Oh,
madam.
sir, okay, okay. As prayed for by Mr. M. Ahmed, learned counsel for the petitioner, list this matter when?
Next, after vacation, lordship.
After vacation, list
Vacation,
this,
lordship, after 1 week, lordship. Okay.
bail matter, right?
Yes, lordship.
Yes, list this matter on 18th of June, next Thursday,
Yes, lordship.
okay, 18th of June.
Thank you.
Ago matter to disposed of, huh? Closed, disposed of. Yes, Mr. Chaudhary?
33, my lord, we filed an appeal of quashing of FIR.
Mm.
Now we came to the charge sheet has been filed.
Oh,
So we have to, go with the liberty to file again, Madam.
okay.
Item 33.
Item 33 likha. Mr. H.R. Chaudhary, learned senior counsel assisted by Mr. S.S. Ahmed, learned counsel for the petitioner submits that he has instructions. That,
Charge sheet.
no, he has, yes, nalage instruction, huh? He submits that,
We filed this
And
quashing
that-
matter for quashing of the FIR.
he has submitted that the instant criminal petition was filed for quashing of the FIR.
FIR.
But during the pendency of the instant petition, he has learned that charge sheet is submitted and as such prays for withdrawing this matter with the liberty to file afresh. Prayer is allowed, matter is closed as withdrawn with the liberty mentioned above.
Always.
May I please? My lord, the item number 36, my lord, supplementary.
36.
My lord, can it be canalized the last item, my lord, before rising? My lord?
I'll try. I'll take up bail hearing first
Yes.
and then I'll go to the motions, admissions.
Time permits, my lord.
Okay, I'll take it before I rise. You come back after doing your other matters. Yes,
Every lordship. Lordship, yesterday an additional affidavit has been filed, lordship.
okay, call
the-
for it. Give requisition.
I beg to mention again, item number 22 of today's list. Okay?
Huh.
Here in this case, inadvertently, I could not take steps, Lordship, it is a POXO matter, Lordship. There is some time available. By Monday, I will take steps.
Okay. I'll pass this order after seeing the audition. You need not be here. Let your junior be here.
May it please, your lordship. Lordship, I beg to mention item number 1, admission.
Hmm.
Lordship, this matter is being led by Mr. Amit Goyal, but he's
He has
having.
some medical problem.
Yes, your lordship. So some accommodation may be provided, lordship.
Okay.
Immediately.
Heard learned counsel appearing on behalf of Mr. A. Goyal, learned counsel for the petitioner, who submits that the conducting counsel has some medical issues and as such has prayed for some time. Prayer is allowed. List this matter on when? After
immediate-
vacation?
Vacations, immediate.
List this matter on 15th of July,
Much obliged.
2026. Yes,
Like to mention item number 31, lordship.
31.
Yes. In this case, lordship, the earlier report was called for, and on
Ah.
earlier occasion, the report was also there, and the other side was trying to go through the report and.
So you want the matter to be taken up?
No, lordship, the issue is that the report is not today, that is not available. today.
Okay, then we will take it up on Monday, Tuesday.
Yes, lord.
You bring the report, Mr. Busha.
My lord.
Okay, on the prayer made by,
Monday, 22nd, lordship.
okay, next to next Monday.
Yes, lord.
As prayed for by learned counsel, Mr.
H. Agarwal.
H. Agarwal, list this matter on 22nd of June.
report as called for maybe.
It is further prayed that a report in connection with the instant case was called for and the same was received, but but to his information, the same is not available with the learned counsel today. As such, a prayer is made that on the next date the report may be may be
Furnished.
made available.
Okay.
Prayer is allowed.
I am sorry to intervene. Refer to item number 5. I have
Item
taken
5.
Consent the other side. Can it be, Lordship, we have also bargained date. Can it?
Mr. Datta, you are there?
Yes,
Yes, I am
19.
for the response.
Can be 19, Lordship.
Okay. You are Mr. AZ Ahmed. Learned counsel, you don't have any option on 19th. 19th of this month,
Yes.
coming Friday. Okay. Heard Mr. AZ Ahmed, learned counsel for the petitioner, and Mr. Surajit Datta, learned senior counsel, assisted by Mr. S.H. Rahman, learned counsel for the respondent number 2. A prayer is made by the counsel on behalf of the petitioner that the matter may be taken up on 19th, which is agreed to by the learned counsel for the respondent, accordingly, listed accordingly. Yes, Mr. Khonikor.
Flag B minor can be,
Huh?
flag B minor.
Flag B. What is there in flag B?
Notice is not served.
Notice not served.
Actually, my lord.
Pokto.
Yes,
Pokto.
they have taken the steps by the, my lord, directly through speed post, my lord.
Oh, that is of course not. It should have been taken through the office of the PP. You take it afresh.
Fine.
Okay, okay, Mr. Busha.
My lord.
Learned counsel for the petitioner, Mr. A. Khonikor.
But my lord, my lord, notice there, my lord. In earlier order, my lord, what I have noticed,
Last
my
order
lord,
to can level open.
my lord, registry is directed to find, my lord, that, my lord. Whether, my lord, it is served on.
Meanwhile, charge sheet has been submitted. Praise for bail. Scan copies. No.
The last
You-
order.
Case diary awaited. No. Oh, last order.
Last
Acha, acha, acha. Learned counsel. Track consignment row has been tagged at flag A. Item has been received at Jorhat. ICH. What is ICH? Hospital. Civil hospital. Yeah, okay. Right. Mr. A. Khonikor, learned counsel for the petitioner, submits that the instant matter relates to an offense or under the POCSO Act, but steps for service of notice upon respondent number 2 was taken by speed post and by speed post, with AD as well as by usual, only by speed post you had taken, right? By speed post. However, he submits that as per the law, in cases under the POCSO Act, the steps for service of notice should be taken through the office of the PP as reflected in the, as provided in the Gauhati High Court rules. As such, he prays that some time may be given so that he can take the steps accordingly. Prayer is allowed. List this matter. You give the copy, list this matter on 25th of June.
I'll take steps tomorrow.
You take steps as soon as possible.
Diploma.
Huh?
The NDPS Act, Lordship.
Case diary is there.
My lord, no, my lord. In this matter, my lord, charge sheet submitted, my lord. We
Or
get
charge sheet
communication, my
submitted.
lord.
You try it there.
Lordship.
If you're unable, come here, right? Instead of keeping it pending, right?
Yes, Lordship.
Heard Mr. S. Hawk,
Yes.
learned counsel for the petitioner, and Mr. K. Bosher, learned APP for the state. Mr. Bosher submits that the case, that the charge sheet is laid in the instant case. Why charge sheet number?
178, 2026, dated 35, 2026.
178, Pala.
My lord, we get a communication, my lord, that may be kept as a part of the report.
Mr. Bosher has placed a communication by which the aforesaid information is,
In connection with Vichista PS case number 132, 2026, madam.
is this the same page number, right?
Yes, madam.
Have you checked?
132, 2026, madam. Subject-
Bosher 132 of 26.
Yes.
Okay. This is 132, right? Just see once, wait. Sometimes what happened, a wrong
Yes, my lord.
is
Some-
passed and 132 of 26. And accused, your case, accused woman or accused, accused is a woman here.
But yes.
Acha, her name is Shahida Khatun, yes, okay, this is the one, right, by which the instructions were given. As such, the learned counsel appearing for petitioner submits that he be allowed to move appropriate application before the appropriate court of law. Prayer is allowed. The present bail application is closed as such. I read it, yeah, the report from the Boshishta police station dated 11/6/2026 is kept as a part of the record.
My lord, DPO.
Petition is closed.
May I please, Your Honor?
Hmm.
Did was call for Your Honor 46 days behind the bar, Your Honor.
Case there is here.
My lord, they pray for a short accommodation because my lord, some cases pending in line, my lord, judicial magistrate, my lord, because of that they send the CD, my lord, not able to send today, my lord. Short accommodation, my lord. They send a written communication in this regard.
This is what offense?
Offense under
Section.
141, 127.
Acha, kidnapping you said, right?
No, victim already recovered on that similar day. Your Honor.
Okay,
Fine,
victim
Your Honor,
recovered, but then the offense still lies.
Yes, Your Honor. but
So-
6 days.
26 days,
46.
46 days. It's okay, we will give a short date. Okay, we'll take it up next week on Wednesday. Same case diary.
11 and 12.
Okay, next Wednesday you bring it for
Fine.
without fail.
My
Hmm.
my
Okay. Mr. K. Bosha, learned, heard Miss
P. Kolita, Your Honor.
P. Kolita, learned counsel for the petitioner in item number
11.
11. And Mr. K. Bosha, learned APP for the state, Mr. Bosha submits that in spite of its best efforts, he submits that that he could not procure the case diary, which is there with the in the court of Judicial Magistrate First Class Kamrup M. And as such has prayed for a short accommodation so that he can place the same on the next date. Prayer is allowed to list this matter on 19th of June, next
Right.
Friday.
my
In item 11,
You are for
item 12, sorry, ma'am.
12,
And
yes.
the manders.
Okay. Item 12 also same order will follow. He will bring the case diary on 19th.
my lord, deeply obliged.
Yes. You are in 12.
15, your lordship, arising out of the same case.
15. Okay.
On the
So
22nd, your lordship.
15 also we will tag along with this.
Yes, your lordship. Maybe taken on 19th, then your lordship.
Yes, my
Oh, 15, which you got detached from
Yes,
16.
yes, your-
Now actually it is related to these matters.
Same FIR.
Okay, 15 on DD, the same day. You pointed out on that day, we will dispose it of.
19th June.
Yes, Miss P. Das, learned counsel for the petitioner, heard Miss P. Das and Mr. K. Busher, same order DD. Oh, 15 to order is passed. Now 15 to me herit kori dia, 19th. Oh, hito kora para ba ekedinai kori dia. Thik ase. List along with so and so. Aru 19th of fix kori dia. 15 order to. Okay.
Deeply obliged.
17. Can you bring it by Wednesday?
We can try, my lord. If not, my
Okay,
lord, then another
Wednesday.
date, my lord, it will be a
Make it
problem.
17
them.
for all the cases. Okay.
Deeply
You
obliged.
try, you bring it. They are inside the jail itself.
Yes, ma'am.
May I please you, Lord?
Yesterday I had no other way out. I had to dismiss your matter.
This one.
No, yesterday's matter.
Your Lordship.
36, what I have said is by clause C, something is done. And 48, since it is sent to the OC and we do not know what happened after that. So, and the requirement is only to give. And so I,
No. Well, with all respect, my lord, the requirement is they have to ensure that it was served up.
no, but then 48, by bare reading of 48 shows that it has to be just
And
given.
then Supreme Court has discouraged the message sending by elected media.
Hmm.
It is not admissible. It is not proper service of this. That's why time and again DK Bosu always comes into the picture that a lawful arrest should be done.
Okay, we will consider.
Yes.
Yes.
My lord,
Yes,
here,
what
my
is
lord,
this?
service completed, my lord. So
Pakto.
amicus may be appointed, my lord.
Okay,
But,
okay.
but this is a very peculiar case, I tell you.
If it is POXO, let me appoint
Yes,
an
madam. So POXO, maybe nowadays POXO has become very common thing.
Yes, yes,
Now,
that
what
is
happened,
known.
madam? Children of age group 3 and 4 years, they are playing with their koka or bordevta. In presence of their mother, all children were in their presence of mother.
Mm.
Then, my lord, probably one of the child was almost going to naked. He put up this jangia, then all these things. And my lord, somebody has complained that it is an offense. Then, my lord, the child welfare committee chairman requested the parents to file a case. They said, no, we are in the field. We have seen nothing has been done. Why will file case? Then she filed a case herself and get the man arrested. 58 years, 58 days behind the bar.
Who had
Did
filed
it-
CWC person?
Yes, my lord, I have annexed the petition, my lord.
It's
Can you-
okay. We will see that.
I-
But the fact remains some minor is involved in the offense.
Yes, yes, I
So
admit, my lord.
POXO-
My lord, there is a limitation of everything, my lord. Bordevta is playing with the children of the group in the field and in presence of their parents, mother. They have said that specifically, they said that with an affidavit, my lord,
And Bordota is
we,
the
madam,
accused.
I have placed Annex 6. We are present in the honorable court on summons, the above mentioned case, served upon us. The victim X, Y, Z of the above mentioned case, our children and minor. At the time of occurrence, we are present with our minor son. We never seen an accused as involved with any alleged occurrence.
So
He said they have filed
Bordeta,
with evidence before the court.
Bordeta is the accused.
Yes,
Okay, let me appoint an amicus. We will hear this.
I have served the
everything.
notice to the parents also. They have this informant, he has not turned up.
Okay. Heard Mr. S.C. Biswas, learned counsel assisted by Mr. Yes, K. Das, learned counsel for the petitioner, and Mr. K. Bosha. It is noticed that the respond number 2 was served with the notice. Respond number 2 only, right? Served with the notice. But however, there is no representation on behalf of the said respondent, and as such, this court deems it fit to appoint an amicus curiae to defend the cause of respondent number 2. Pretty Das. Who know? Accordingly, Miss Pretty Das. Pretty Das. Miss Pretty Das is appointed as the amicus curiae to defend respondent number 2. The learned counsel for the petitioner is directed to serve the necessary copies upon the said. Do you know her? Do you know her?
I do not know. I will collect the telephone number, I will give it.
Okay.
Well, let it come Monday, my lord.
Huh.
Unless
At
I
the
manage it.
earliest, give
Under these
necessary
circumstances-
copies to the learned counsel for learned amicus curiae at the earliest. TCR is here.
TCR receipt, ma'am.
Okay. List this matter on.
Monday, my lord.
Huh?
If possible, my lord.
No, you will serve her copies. Let her also
I will
go
start
through.
today itself.
So, okay, provided you find her. So let it be listed on 17th, Wednesday. List this matter on 17th.
See, they have telephone number.
Yes, Mr. Chaudhary, you are waiting for some matter? Supplementary 20. Can I take up his matter, Mr. Poddar? Yes. 20 to deduct, no? It's- 20, bail,
28
8.
daily,
It's a bail matter.
anticipatory.
Achha, achha. Normally, we don't see you handling such matters. Yes, 28. Mr. Parasha, you appearing?
My lord.
Yes, 28.
My lord, the FIR is at page number 19. Sorry,
Hmm.
sorry.
There is some order
Yes.
sheet here. FIR is page 19,
Page 13.
13.
With reference to the subject cited above, I have the honor to inform you that on 21/5/26 at about 11:30 AM, it was allegedly reported that 5 youths in a bolero from Shillong were robbed of rupees 25 lakhs in
Hmm.
front of the Assam Oil petrol pump near Hotel Radisson Blue on NH 37/2% in a bolero impersonating crime branch officials. That cash was the hiring charge of excavator engaged in works, at a site near Umsing, which was collected on the said morning from Umsing,
Hmm.
collected on behalf of Bijul Ali, who is the owner of the excavator. The alleged accused also snatched the mobile phone and vehicle keys, and they complied as accused claimed to be crime branch personnel.
Hmm.
Accordingly, the matter was inquired and alleged victim, namely Asif Ahmed, then Milord Formud Ali, then number 3 Rinku Ali, and number 4 Bijul Ali were thoroughly examined. On examination, certain contradictions were found in the statement, and the incident appeared to be a concocted and fabricated story prepared by the 4 complainants. Upon sustained examination, they revealed that the said amount of rupees 21,85,000 was collected from Singh and is proceeds from illegal cattle smuggling carried out by the 4 individuals. The false recovery story was pre-planned conspiracy hatched by 2 other partners of these 4 individuals, namely Azmal Ali of Mongoldoy and Mehboob Ali of Mandakata. This is the petitioner, Miller.
Azmal Ali and Mehboob Ali are not victims.
No, Miller.
Hmm.
Mehboob Ali is the petitioner.
Hmm.
These 2 associations were already present in the informant's Bolero car and immediately left with the alleged accused after the staged incident. The intent was to cheat their share partners and misappropriate the entire amount. Henceforth, by lodging a false report of robbery by person impersonating crime branch, the said individual have misled the police with false information and attempted to defame the police department with a false charge. Thus, it is established that the 4 individuals in connivance with other 2 absconding partners are involved in illegal cattle smuggling. They deliberately furnish false information to mislead investigation and escape from police action from hatching the conspiracy of designing the entire incident. Because actually what had happened, these 4 persons, Asif, Formod, then Milord Rinku and Bijul, they went to the police station and lodged an affair that they were carrying a sum of rupees 25 lakh, which has been robbed by some person impersonating themselves as crime branch person. Manmala, all these 4 were arrested and they've been released on regularly. All these 4. Now, Manmala,
No,
where from I have been imported.
all these 4 means these 4, no? Right.
Yeah. Milord, this is Asif,
Farmod and all.
actually, Milord, Bijul Ali, he is the owner of the excavator, and other 3 are his employees. Now they are actually, Milord, doing some land deals, land excavation. So they say that they were actually, maybe it was a ploy, Milord. Maybe there was a partnership business just to inform the police that money has been taken away. So they need not pay the share of the booty to the others. Well, that it is a sale proceeds of cattle smuggling alone. This is absolutely, this is not based on the figment of imagination of the IO, my lord, police officer who has written this affair. There's absolutely nothing. While the other 4 were arrested and they were produced, my lord, nothing of this sort. At best, my lord, it's a case of 2-1 cell. That were the instance of this 4 person for giving wrong information. It's a bailable offense. That's why, my lord, the other 4 has been released on bail. My lord, my name has figured because this Bijul Ali has informed the police, as this recorded in the bail order of Bijul Ali, that we have asked them to toll this way. That's the only thing.
You have asked them to lodge the FIR.
No, lodge the FIR on the false pretext. But where from? I have figured, I don't know. I've been unnecessarily dragged into the whole thing.
No,
There is
2
nothing
persons,
like-
persons who ran away, fled away. Who are those 2?
No,
These Mehboob or somebody?
No, yes, that is what they're trying to say. No, my lord, if I was not in the police station, neither this other gentleman called Azmal Ali. I'm Mehboob. So, my lord, my humble submission is the 4 person who lodged the false affair, that some person impersonating as crime branch people took away their money and all. They have all been released on bail.
I think the crime branch people whom they wanted to project is Mehboob and this
No,
one.
my lord, supposing I have said,
Huh.
what is the my lord material to say that? My lord, actually, the idea is possibly these 412 cheat Miller, Ajmal and Mehboob.
Hmm.
Maybe these six did the same, that excavation work together.
Hmm.
Now they were carrying the money. So if
Hmm.
they can plant a story and say that money is gone, then they can
Yes.
eat up the whole amount. The story could be that way, Miller.
Yes. There can be many.
Therefore,
But-
Miller, at this stage, Miller, I am praying for some protection. Let
This
my
is
learned friend-
AB or BA?
AB.
Okay.
So
So as far as Mehboob
Matlab,
is concerned, yes.
So the first, they are the arrested persons, they gave, 4 persons, their statements are two different statements. Earlier, they have said that some persons impersonating as a person.
Two persons.
Yes,
Uh-huh.
they have snatched away the money.
Hmm.
But subsequently, when investigation progressed, they gave the statements, may kindly peruse.
Hmm.
41 numbers of cattle they bringing from Mongolia and sell at Meghalaya side. Subsequently, they got those amount of money, 21 lakh something, 85,000.
Hmm.
And Mehboob as make the plan that may kindly peruse.
Whose statements?
uh,
Victims.
Victims.
they are
And this-
again-
Yes. No.
They are accused also.
Yes, they are co-accused. Yes. Investigation stays still going on. Still investigation is going on.
But
And
then it
there
will
is
be
a-
the
there is a-
statement
there-
of
on the
co-accused.
basis of- Yes, on the basis of the, on the basis, yes, but it's still in investigation stage and the IO, on the basis of his investigation, IO has given an objection also, kindly peruse the objection of the IO and the statements of the accused, kindly. Wow, what else? Now
At the same
investigation
time,
has
Milan,
started.
I am also producing the 2 bail orders of the person
Hmm.
who were responsible for giving that false affair.
Acha.
These are the 2 bail orders.
They were arrested, subsequently granted bail, regular
Uh-huh.
bail.
No cattle has been recovered,
No, cattle is not.
nothing has been done, no money has been recovered, nothing has been done.
And amount is also, it also got changed. It was 25 lakhs and now it has become 21 lakhs.
21 lakh 85,000.
Was collected from Umsing and his proceeds from so and so. There were no the false robbery story was statement. Which by two other partners of these three female these two associates were already present in the
Second time.
car. So what, I'm still on the FIR. These two associates means Mehboob and Ajmal.
Yes.
They were with the informants meant along with the other 4.
Yes.
Yes.
6 were together.
They fled away.
Informants Bolero car immediately left with the alleged accused after the staged incident. The intent was to cheat their shared partners and innocent arrangements by lodging false report of. Then 4 were interviewed, 4 were investigated. Then why not these 2?
They fled away with the money.
No, they say that see, the false robbery case was hatched by so and so. These 2 associates were already present in the informant's Bolero vehicle
Yes.
and immediately left with the alleged accused after this. So they left
2%,
along with the 4 persons.
They left with that money and subsequently these persons stated that some person has taken the money, but the whole plan was of this memo.
No, it is said, but see, initially the police officer says that all those 4 were questioned, and they did not give a proper answer, and so they investigated further. But then, what about these 2? Why these 2 who were there along with the 4 were not asked questions? It is said that they left with the other
left
4, but then they were not investigated on. They were not examined.
They were not examined. They fled away.
They fled away along with the other 4. So all 6 went together back from the police station after lodging the FIR. So why these 2 were all not examined along with the other 4?
Perhaps these 2 persons fled away
Your
with
story
the
doesn't seem to be very.
It's a very cooked up story, Miller. Please come to Miller, that bail order of Bijul Ali. Please come to para 7, Miller. Why I have been dragged in. He said, Miller.
Achha.
Please
So
come
let
to-
me see the
Yes.
statements of Asif.
Yes.
Asif is the other one.
Yes, Asif with the other one.
मुझे statement के लेसन पर क्यों है? मैं आसिफ को देखो.
না আসিফ 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 আছে আসিফ আহমান রিঙ্কু আলী ফকরুদ্দিন এন্ড ফরমুদ আলী এই দুটো these are the other person.
So what does Asif Ali say? That he is the driver of Mehboob and they are engaged in that business. Then what else? I along with absconding.
But with an excavator, we cannot carry cattle, Milo.
Huh,
We can only dig.
excavator
We can take out land.
has to
from
be
the
a
earth.
truck.
It's an excavator, not a truck.
Cattle carrying truck.
No, it is
He-
not a
he
truck,
said.
Milo. What Bijul owns is a excavator.
Huh.
My name has been dragged in because Bijul made a statement. Milo.
Asif also had said about you.
Ah. Co-accused. In any case, it's a statement of co-accused.
Mm. And what about IO's report you said? Which mark?
This the,
Purple.
extra page two sheet page.
Extra page. Oh, extra page. This one.
Yes, yes.
Which point that I represent? On what basis he had said that this is the total hatching of conspiracy by the
Mehboob.
Mehboob? On what basis he has said? On the basis of statements of the co-accused?
At this stage, yes.
Yes, this is only a investigation stage.
Investigation stage. Just FIR is lodged in Malad recently, Malad.
But
21-5.
it's not clear. Okay, heard Mr. K. M. Chaudhary, learned senior counsel, assisted by Ms. T. So,
But if at all this money has been gone, Malad is a huge amount, 21, 20,
Hmm.
that is, the money has not been recovered now.
that is for the police to go.
Yes,
He
yes.
is only on bail. He will be on bail only, right? With conditions.
Malad, he will come with the bail order and he will
He will
nothing
flee.
say about the money, Malad.
He will not flee. Our police's hands are not so short. Okay, so T. Som, learned counsel for the petitioner, and Mr. K. K. Parashar, learned APP for the state. By this application, the petitioner has prayed for bail, for pre-arrest bail in connection with Jalukbari PS case number 185 of 2026, registered under section 61 subsection 2 slash 303 subsection 2 slash 317 subsection 2 slash 3248 slash 217 slash 240 of the BNS 2023, read with Article Section 13 of the Assam Cattle Preservation Act 2021. The FIR, in connection of which the petitioner is charged under, is lodged, was lodged on 22/5/2026, and it is revealed by the said FIR that on 21/5/2026 at about 11:30 a.m., a case was registered. A case was an incident was informed that 5 youths in a Bolero vehicle were robbed of rupees 25 lakhs while they were coming from Shillong. And the said robbery was stated to have been done by 2 persons in a Bolero. 2 persons coming in a Bolero who impersonated themselves as crime branch officials. Full stop. It was also stated in the said report, in the said information, that the said money were in connection with hiring charges of excavators engaged in a work site near Singh. It is thereafter stated in the instant FIR that pursuant to the said information, an inquiry was conducted and statements were recorded. An inquiry was conducted and four so-called victims were examined. And on examination, contradictions appeared in their statements. And on further examination, it was revealed that the said amount, which again underwent change, that is rupees 21,85,000, were the proceeds from illegal cattle smuggling, and that a false robbery story was projected by the said victims. And it is also stated that apart from the said so-called victims, two other individuals were involved, and further that the petitioner had hatched the entire conspiracy along with another. It was also stated in the FIR that the petitioner along with the other were present in the Bolero vehicle where the informants, that is the four persons, were present, and that the said petitioner along with the other had fled the scene. Mr. Chaudhary, learned senior counsel, submits that the involvement of the petitioner was incorrectly made, as he was not there in the said vehicle, and that the entire story is a cooked up story. He submits that at best it can be a case of wrong information, but the registration of the FIR under the aforesaid sections of law against the petitioner was not correct in the eyes of law. Mr. K.K. Parashar, learned APP, submits on the basis of the statements of the co-accused, namely Asif Ahmed, who had stated that the entire conspiracy was hatched by the petitioner to misappropriate the entire amount.
Asif Rinku Ali also there.
Rinku Ali also. He has also placed a statement of the other co-accused, who was initially the informant of the previous information that the petitioner is involved in the offense. Upon consideration of the submissions made by the parties and on perusal of the FIR, it is noticed that the informant of the FIR dated 22/5/2026, who is the Inspector of Police of Jalukbari PS, it is not discerned as to why the petitioner and the other person, that is namely Asif Ajmal Ali, were not examined when the other four victims, so-called victims, were examined after they had given the information as stated in the FIR. It was simply stated that the petitioner, along with the other, had left the place after completion of the examination of the other four victims. Further, the statements placed by the learned APP are also statements of the co-accused. In view of the said facts and circumstances, this court deems it fit that the petitioner be released on pre-arrest bail on furnishing of a bail bond of rupees 20,000 with one local surety of the like amount to the satisfaction of the arresting authority. Under the following conditions, he will appear before the investigating officer or arresting authority within a period of 10 days from the date of the order. He will not he will not hamper with the evidence, neither influence the witnesses, and he will cooperate with the investigation by appearing before the investigating officer as and when called for. Petition is disposed of. এইটো ঠিক আছে এইখিনি জাজমেন্ট সোমক দি দিব পাৰা সোমক দি দিব পাৰা Yes, Mr. Parasha, you can take your case diary.
My lord.
Lordship, in this case, this is a case of cyber.
The story does not seem to be correct, so let he
Lordship,
be on
I am
bail. After that, they will
93
investigate.
days.
Yes,
And in the similar case, Lordship has, this court has granted bail to the co-accused Lordship.
this one,
Non-compliance of 35, 3, and of considering the period of
35-3 means what 35-3?
non-service of notice of 7 years.
Service of notice.
Out of the same affair, Lordship.
Okay. Oh, I forgot, what is the fact here?
The same
He
affair,
is the
Lordship.
co-accused.
Co-accused in the same affair, Lordship.
Acha.
Same Lahori Ghat PS 16, public 26, Lordship.
Are it 53 days?
You are also an associate
Yes, Lordship.
of Dilwar Hussain.
Dilwar, Lordship.
Of Dilwar Hussain.
Yes, Lordship.
He has withdrawn.
For distributor.
Yes, transaction on his part is 20,66,000.
It was in my name only, Lordship. Bank account was controlled by somebody.
Actually, 35-3 notice is not given.
Not,
That is also mandatory, 7 years and less.
Otherwise also he is completed 53 days today.
This is bail application.
yes, Lordship.
BAP.
Okay, same FIR you said, same fact.
Same affair.
তেতিয়াহ'লে তুমি এইখিনিকে লিখি দিবা এইখিনি facts খিনি লিখিবা now what is the name of the petitioner Mehdi Alam Bhuiyan
Mehdi Alam Bhuiyan.
he also works under Dilwar
Yeah,
Hussain
Dilwar.
Transaction on his part is more than 20 lakh, 20 lakh,
Hmm.
66,000 something.
okay we will not go into that
Minor.
only that 45 44 41A notice not given
Now 35-3.
now 35-3 otherwise his involvement in manipulating money that will be seen in the trial এইটো similar কৰি দিবা খালি মানে এইটো এইকেইটা চেঞ্জ কেইটা মই লিখি দিছো হা Oh, what poddar you write? K,
Poddar.
SK. বাকি একো চেঞ্জ নহয় মই একো বেলেগ দিয়া নাই না bill is given it একে লিখি দিম কিন্তু বেলেগ তাৰ ক্ষেত্ৰত মই একো দিয়া নাই I mean see up during correction I'll just see the FIR. Where is the FIR?
At page 16 onward, Lordship.
16.
The main content is at 20, Lordship.
Just to see, this is the same
20.
one. Yes, Dilwar Hussain, super really. Hamza, employee recruited by.
My name is at page 21.
Ah, yes, Amir Hamza. What was your name? I forgot.
Mehdi Alam,
Mehdi Alam Bhuiya.
11F.
91 fraudulent beneficiaries. আচ্ছা তাতে আমির হামজা আছে নেকি চাওঁ এবাৰ আমির হামজা
This was Mehboob, Lordship. Other two have been granted pre-arrest bail. Lordship.
Okay, this is Mehboob Hassan.
Mehboob.
Okay. Nine. Amir Hamza ek not have. It was appointed at same facts. Amir Hamza was appointed, right?
Dilwar is the name.
Dilwar Hussain is the super distributor.
And
Right.
Amir Hamza was the then BC,
Yes,
probably
yes.
business correspondent. Ajay.
Amir Hamza's
Lots.
mobile. Yes, yes, same. Okay,
Lots.
disposed of. Yes, 17.
17, my lord, as per office note 4/6/26, my lord, service report not received. But thing is that it's more than 1 month. Amicus maybe.
Amicus, POCSO matter. Heard Mr. F. Hussain, learned counsel for the petitioner, and Mr. K.K. Parashar, learned APP for the state. It is, the office note reflects that service of notice upon respondent number 2 is not complete. And on further perusal, it is found that the steps have been taken long back and service is not yet completed. As such, this court deems it fit to appoint an amicus curiae to defend the cause of respondent number 2. Accordingly, Srimati Nirmala Chaudhary Nirmala Chaudhary is the junior to Mr. A.K. Bhuiya, I think. Nirmala Chaudhary is appointed as the amicus curiae. List this matter on FTCR is here.
CD.
Oh, CD. List this matter. So on a short date, so that the CD is retained. List this matter on 16th of June, Tuesday, 16th of June 2026. It is further directed that the learned counsel for the petitioner would supply the copies, relevant copies to the learned amicus curiae at the earliest.
Deeply obliged.
My lord, 18 and 23 is
I think out of
same FIR.
So 23 to DD1. So
they are on
18
inter-
case diary is there.
Yes.
They are on interim, as per my instruction, they appear before the investigating officer. But in item number 23, that is the family members of the husband, their statements were not recorded by the investigating officer, although they appeared before the investigating officer.
And they also have interim with them.
Yes, they are also on interim.
So why were their statements not recorded?
It is the discretion of IO, he says not required, so we cannot force him. That is my answer.
Otherwise, there is my lord, allegation against the other my lord, mother-in-law and brother-in-law. My lord, when the husband beaten up this lady, my lord, they didn't help her. That was the statement of the, as per the
Oh.
victim, my lord. So some allegations like that.
He's a maidservant.
Some allegation against the mother-in-law also
Between
there.
husband and wife, it is already resolved between them, Lordship. And considering that the interim was granted, and in fact, Lordship, before the learned session judge also, she personally appeared and says that she has no any objection. but noticing the facial expression said by the PO, not by the court, Lordship. My bail was rejected. And Lordship, after that, Lordship, she filed an affidavit before this Honorable Court, page 19, that she is willing to resume her matrimonial life and she has no any objection to the granting of bail. So
Okay,
matrimonial,
let me deal with this first one first.
Lordship.
I
Is
mean,
the-
here his statement is recorded. Mr. Parashar, no issues in giving bail.
But thing is that malat alia there is a miscarriage for his
Assault.
assault, and there is a medical report, bite mark on on the right forearm, and malat injuries are there, though some blunt force also there, and as per the statement of the victim, uh, Ariful malat, yes, he is the Ariful, yes, Ariful malat, স্বামী মোক পেটত গুৰ মাৰি, yes, miscarriage also for his assault, but subsequently malat, for their relationship malat, she came back, but thereafter malat স্বামী দুদিন যোৱাৰ পিছত মোক 3 তালাক বুলি কৈ মোক আকৌ ঘৰৰ পৰা খেদি দিয়ে. Now she is, as per her statement, she was in the home of matrimonial home. No, not in matrimonial, in her father's home.
Paternal house.
Father's home. So as per her statement.
Otherwise, he has assaulted her and there are
Assaulted,
reports.
miscarriage and all this malat, there, but first instance she came back thinking about their
So
relationship.
this is 498A case or
Uh,
323 and all.
98 is also there.
498 is also there,
Also
but
there.
a section of miscarriage is
No,
also there.
those things will be taken care by the court. As far as bail, he is cooperating.
But regarding others malat, there is nothing malat.
Others are who?
Others, mother-in-law, brother-in-law, and they didn't help while he is
Hmm.
assaulting, malat, they
They
didn't
did
help.
not help the victim.
But some malat in the case dari malat, there are malat transactions through Google Pay from the matrimonial to the Ariful directly, malat 50,000,
Who
45,000
pays those to Ariful?
to the by the family members of the girl victim.
Of the victim. Oh, the dowry demand and all.
Malat, yes.
So, number of allegations against the husband.
So my objection is against the husband. Still, though interim is there, malat, my objection against the husband. Others, malat, in the next item, malat, I don't have any objection, malat, because
Regarding
they are
husband,
material.
Lordship will consider that during, while his bail application was filed before the learned session judge, wife herself appeared. Before this honorable court, also she filed one affidavit after rejection of that bail application.
Oh,
Now they are trying.
She always wants to reconcile
Ultimately,
and
he
get
also
back.
he also, Lordship, now wants to resume their matrimonial. Considering that aspect, Lordship may consider. Otherwise, I am not on merit. I have initially also I have said about settlement only, Lordship.
Okay, heard Mr. A. Ahmed, learned counsel for the petitioner, and Mr. K. Parashar, learned APP for the state. By this application, the petitioner has prayed for bail in connection with pre-arrest bail in connection with Bhuragaon PS case number 7 of 2026 under section 85/89 of BNS 23, read with section 3/4 of the Muslim Women within bracket Protection of Rights on Marriage bracket close Act 2019. It is noticed that the petitioner was released on interim pre-arrest bail by this court by the order dated 13/5/2026 with the condition that the petitioner should appear before the investigating officer within 1 week from the date of the order. And on perusal of the case diary, it is further noticed that the petitioner had appeared before the investigating officer and his statements were recorded in compliance of the direction given by this court. However, Mr. K. Parashar, learned APP, objects to granting of the pre-arrest bail on the ground that the case diary reveals that petitioner is involved in assaulting his wife, and in pursuance to the same, the wife had to undergo miscarriage, and also and there are also medical reports showing injuries on the body of the petitioner's wife.
Petitioners.
However, it is also stated that the petitioner's wife desires to stay with the husband, and there are occasions when she came back from her paternal house to her husband's house to resume the marriage. On consideration of the submissions made by the learned counsels and on perusal of the case diary as well as the last order dated 13/5/2026 and the compliance made by the petitioner, this court deems it fit that the petitioner, deems court fit that that order dated 13/5/2026 granting interim pre-arrest bail to the petitioner be made absolute. However, with the rider that petitioner has to follow the conditions mentioned in the said order. Okay, petition is disposed of. Since we want to, I can resume life and all. then-
Others,
Oh, the
23.
other one. Item
23.
23.
No sufficient,
Hmm?
as for the victims.
Heard Mr. A. Ahmed, learned counsel for the petitioner, and Mr. Etu Rakethaiwa. By this application, the petitioners or who?
Petitioners. Three persons.
So many.
Mother
Mother-in-law.
and two brothers.
Petitioners who are the mother-in-law, comma, brothers-in-law, two brothers, two brothers-in-law of the alleged victim of the FIR. কি বলে আরম্ভ করলো? File বেড়ে। No, প্রথম আরম্ভণিটা কি? That's the by this application, the petitioners so and so have filed for pre-arrest bail in connection with, has filed the present application, for pre-arrest bail in connection with same case number, in connection with Bhuragaon PS case number 7 of 2026 under section 85/89 of BNS, read with section 3 /4 of the Muslim Women Protection, so and so. It is noticed that the petitioners were enlarged on interim pre-arrest bail by order of this court dated 26/5/2026 with the condition that the petitioners shall appear before the investigating officer within 1 week from the date of the order, and in compliance of the same, the petitioners appeared before the investigating officer, but it is stated by Mr. K.K. Parashar that their statements were not recorded. Right?
No.
Were not recorded. Full stop. However, it is seen that the allegation against the petitioner is only to the extent that when the husband had beaten up, when the husband has tortured the wife, they, being the relatives of the husband, did not object to the same or help the victim. No other allegation as such is reflected against them in the FIR dated 3/3/2026. As such, this court deems it fit that the interim order dated 26/5/2026 be made absolute with the further condition that the petitioner shall appear before the investigating officer within a period of 10 days from the date of this order and get their statements recorded. It is also directed that the investigating officer will record their statements.
That direction may not, because it is the discretion of the IO. They will
That
appear as and when.
as and when called for, my lord.
As and when required, they will appear.
Okay, detail about that. With the condition that the petitioners will appear before the investigating officer as and when called for and would cooperate with the investigation. Petition is disposed of.
How long?
19 to 21.
No, please, my lord.
Hmm.
Item 21 is the bail application, my lord,
Mm.
and 19 and 20 is anticipatory bail application, my lord.
Mhm.
Item 21 is my let's say bail application, and 19 and 20 is a anticipatory bail application. And 21, my ladyship, it is 91 days is languish in jail, my ladyship. So maximum period is 90 days. So as far as the 21 item is concerned, I'm pressing for the default bail, my ladyship.
Mm.
And as per 19 and
So charge sheet is not submitted?
yes, my
Mr.
ladyship. that's it.
Charge sheet is not submitted, my lord.
Yes, my lady.
And what is the offense here?
Offense is attempt to murder, my ladyship, section 109.
Acha, so 90 days
90 days
is
is the
inside.
maximum period, my ladyship. It's 90 days, so I'm praying for
Say,
default.
Mr.
My lord, actually, prime is my lord, Asik Khan, my lord, item number 19.
Mm.
He beaten, my lord. And my lord, the injury is also serious. He hurt my lord with a brick.
Mm.
And my lord, the 21, my lord, he's the father.
Acha.
Father of my lord Asik, father of
Oh.
item 19. The my lord, he associated with his son
Hmm.
in beating that, my lord, the victim.
But he couldn't abscond.
My lord, he could not abscond. That's
He is
why
arrested.
he caught hold of the police. So, my lord, my objection mainly on, my lord, item 19.
Okay, 21, we'll do one thing. 21, I'll pass the order of
My lady,
default bail.
My lord, my lord.
Okay, heard
My lady.
Mr.
Aramin, my lady.
R. Amin, learned counsel for the petitioner, and Mr. Bankim Sharma, learned APP for the state. By this application, the petitioner has prayed for regular bail in connection with Howley PS case number, regular bail, regular bail for his arrest in connection with Howley PS case number 26 of 2026, registered under section 296/126, subsection 2, 117, subsection 2, 109/3, subsection 5 of BNS 2023.
So, 30.
The FIR dated 12/3/2026, registered against 3 accused persons, one being the petitioner, was filed. And the same had revealed that on 12/3/2026, that is on the same day, at night hours, no.
Not at night.
Inter alia, that on 11/3/2026, সেইখিনি বাদ দিয়া, same day, night hours, that on 11/3/2026 at about 4 p.m., the son of the informant was playing cricket with other boys. And during the said game, an altercation took place between the victim and one Ashik Khan, who is one of the accused person. And following the altercation, said Ashik Khan called his father, that is the petitioner, to the field. And that thereafter the quarrel had again taken place. And in the course of the said quarrel, Ashik Khan, the co-accused, struck the victim on his face with a brick causing severe injury. And that the victim was taken to the hospital and the resultant FIR is lodged under the aforesaid sections. The learned counsel for the petitioner submits that the petitioner is the father of said Ashik Khan and he was arrested in connection of the aforesaid offense on 14/3/2026 and he has been inside the jail since then. And today, it is the 91st day, 91,
Yes, ma'am.
91st day of his incarceration. And accordingly, he submits that since the charge sheet is not filed till today, the petitioner is entitled for default bail. It is noticed that petitioner has been in jail since 14/3/2026 and he being inside for a period of more than 90 days, the petitioner is entitled, as stated, for in default bail. In view of the same, the petitioner be released on bail on furnishing of a bail bond of rupees 20,000 with one local surety of the like amount to the satisfaction of CJM.
CGM Borpata, my ladyship.
Uh-huh.
CGM Borpata, my ladyship.
CJM Borpeta, under the following conditions, he will appear before the investigating officer as and when called for. He will not influence witnesses. He will not hamper temper evidence. Petition is disposed of.
As per the item.
Ashik.
Yes, ma'am.
Ashik is what?
My lady, may I argue the case on 21st, my lady? Item number 20, same connected matter, same.
20?
Yes, my lady.
Abul Kalam. Who is
Yes,
Abul
ma'am.
Kalam?
He is the uncle of
He's the uncle.
Borpata.
He is also on the spot.
But his name specifically is not
Nothing
mentioned.
overtake, no overtake, nothing
But
against
my
him.
lord, witness and my lord, as well as my lord victim, name him that he was also present in the my lord spot when. my
It's
lord-
okay. Two boys were playing cricket, na?
Yes, ma'am.
And okay, Mehboob Khan's name was there.
Yes.
Mannaf Khan.
Along with his
Hmm.
brother, Kalam.
Acha, acha.
His
So,
name was also there.
Kalam and Mannaf are brothers.
Yes, ma'am. Brothers.
So I want to.
Uncle and father of the Asik.
আচ্ছা শুনা একেখিনি ফ্যাক্টস দিবা খালি পেটিশনাৰ নাম কালাম পাৰিবা তুমি পঢ়ি গলে গম পাই যাবা ওকে
So
আইটেম 20 কালাম সো এইটো কো লার্নার কাউন্সিল ফর দি পেটিশনার পৰা বদলি যাব only facts will remain the same learned counsel for the petitioner submits that the petitioner was not specifically named in the said FIR. Right. What are your submissions?
my name is in the FIR, by my lordship, no overtake, no
Overtact is
covertake,
not.
and in the no specific allegation against the Kalam, my lordship. He was not there, neither in the reference drawn against him, my lordship. He won the spot after the
Yes.
entire incident complete. May I submit?
There's-
After the entire incident complete, he went there. As the uncle has the concern, his niece was there, he went there. But nothing against him in the mansion. So my respectful submission before your ladyship that as far as the Ashik Khan is concerned, that no specific allegation, no overtake, covertake mentioned. So he may be enlarged on bail and his
As
brother.
far as Kalam Khan is concerned.
Yes, my lordship. As
Kalam.
brother is
Okay.
languishing 91 in jail, so investigation substantially progressed, my lordship. Within 3 months past. So that is the submission.
Okay, learned counsel for the petitioner submits that although the name of the petitioner finds mention in the array of accused persons in the said FIR, but no specific overt act, overt act is ascribed to the petitioner. Full stop. He further submits that the petitioner being the uncle of said Ashik Khan reached the place of occurrence after the incident had taken place. That is, after the victim was injured, for the well-being of all the persons present there. And as such, and further, he submits that investigation has reached to a substantial extent, and as such, his custody is not required. his custody by the police is not required. In view of the fact, not required, and has prayed for bail. Mr. Bankim Sharma, learned APP for the state, submits that the petitioner went to the place of occurrence and started quarreling with others, in consequence of which said Ashik Khan had hit the victim on his head, resulting in serious injuries of the victim. Para considered the rival submissions of the parties, and mainly on the ground that petitioner is not stated to have done any specific act resulting in the injury of the victim, this court finds it fit that the petitioner be released on pre-arrest bail on furnishing of a bail bond of rupees 20,000 with one local surety in a to the satisfaction of the arresting authority under the following conditions. Petitioner will appear before the investigating officer within a period of 10 days from the date of this order. And petitioner will not influence witness, will not hamper temper. Petition is disposed of.
May I go on?
Ashik.
Yes, my ladyship. My
Ashik also is a young boy. It
My
seems.
ladyship,
What is
may
the
I-
age?
My ladyship, may I just submit few facts before your ladyship? In this particular case, my ladyship, the entire investigation carried out by with due profound respect to the investigation officer, have been carried out complete prejudice to the petitioners. And this petitioner, Ashik Khan, is also a victim. May I just point out the page number 28, my ladyship, kindly count, 28 number page.
Hmm. Yes.
Your lordship can say that he,
28 is not there.
my lady, my lordship, may item number 21, the page number 21, my 23.
Item
Item
21.
number, my ladyship, Munnab Khan, item number 20, my lady-
21 to dear Nayaman.
21, my ladyship, kindly come, my ladyship. Page number 26, my ladyship, come. For a
Of
moment.
21.
21, my ladyship, item number. Kindly come for 26 number page, my ladyship.
Hmm.
And to reveal some facts before your lordship.
Hmm.
Kindly come to page number 28, my ladyship. 26,
28.
my ladyship, 26.
26, yes.
It is from the particularly what happened. Both the accused and the victim, both are victim and both the accused, my ladyship, while playing the cricket regarding a decision either out or not out.
Mhm.
In that altercation heat of the moment, both party beat on another.
Hmm.
In this what happened, the complainant's son Shamsul Haq, he bet with the petitioner, strike with the petitioner with the bat. In that, his might let you kindly see the impression of the case number 26.
This is
The
Asif
petition-
Khan's injury report.
Yes, my lordship. His complete femur has leg of the femur is completely broken, my lordship. But though FIR had been submitted before the investigation officer, not registered. Thereafter, he filed a complaint with the SP for registered his FIR. So nothing repaired. So my respectful submission is that both the young boys, while playing cricket, some altercation happened. That is the main fact, my lordship. And as far as this involvement is concerned, both accused petitioners and the victim, both are victim, both the accused here is. So my respectful submission, the 3 months have been elapsed. The investigation is hugely progressed, and his own father, 90 days just languished in jail, my ladyship. And is a young boy, my ladyship, may lordship kindly consider, and he will completely cooperate with the investigation, will not hamper or temper any evidence. The same will
Okay.
be.
Heard Mr. Ekhini Dibake.
Aramin fine.
Facts to read you. Aramin, yes. By this application, the petitioner has sought for bail in connection with in pre-arrest bail, pre-arrest bail itu. In connection with ago to pre-arrest, the FIR, wherein the petitioner's name appeared as the accused, was lodged on 12/3/2026, by which it was revealed that on 11/3/2026, at about 4 p.m., when the son of the informant was playing cricket with other boys, an altercation broke out between the victim and the petitioner, and that the petitioner, during the said altercation, called his father, and thereafter, again there was a quarrel between the parties, and during the said quarrel as well, the petitioner is alleged to have struck the victim on his face with a brick, resulting in the injury of the victim. The learned counsel for the petitioner submits that it is not a case where only the victim was injured, but also the petitioner. He has placed the medical report of the petitioner, wherein it is reflected. Page number, what you said?
Page number 26, my lordship.
Wherein it was reflected that the petitioner was injured on his leg and the injury was serious in nature. He also stated that an FIR was sought to be lodged by the petitioner in respect to the said incident, but the same was not registered by the officer in charge of the respective police station, and that thereafter an information was given to the superintendent of police, which again was not considered by the police authorities. It was also not considered.
It was given, they have said that we will direct the investigation to register the FIR. But as per the petitioner is concerned, nothing have been registered.
It is not registered, right? He as such submits that the altercation was between the two boys and there was no intention on the part of the petitioner to hurt the victim, neither it was the intention of the victim to hurt the petitioner. As such has prayed for bail. Mr. Bankim Sharma, learned
Only, my lord,
PP.
one line, my lord, incriminating material against the present petitioner in that case.
Submits that there are incriminating materials in the FIR lodged by the complainant to the effect that injury was caused by the petitioner to the victim. Upon consideration of the submissions made by the learned counsels and on consideration of the fact that the quarrel and the quarrel and assault took place while the petitioner and the victim were playing cricket, and both the boys were young in their age, and injuries were caused to each other, as is reflected in the records. As such, this court finds it fit that the petitioner be released on pre-arrest bail on on furnishing of a bail bond of rupees 20,000 with one local surety, aka. Petition is disposed of.
Deeply obliged.
22, my lord, charge sheet file. Charge sheet number, my lord, 28 to 26.
22,
dated, my lord,
somebody took
25.
time or what?
22, 22.
22 Fazar Ali.
Yes.
So, okay, charge sheet file, you go before the trial court.
No, here, Lordship, may kindly say, there are two cases where there, one filed by
Yes,
ours
yes,
and
yes.
one was another side. So which?
Cross cases.
Yes, cross cases. Because as per my instruction, the
Kajolgaon,
cases from our side.
Kajolgaon 35. 35.
Kajolgaon 35.
35.
Well, where is your FIR?
In that case, Lordship.
Take
may
Kajolgaon
call for the
35.
record,
Wait a
because
second.
here, section 4 is there. So if he goes and appears there, he will be taken into custody.
No.
Because
No, even the, what?
no, here facts of the case, just I'm giving you.
Kajolgaon
Here
40.
what happened, the victim girl was having affair with my brother.
Pokto.
Victim girl was having affair with my brother.
Oh.
The family, she came to our house. Thereafter, his family member, her family member came to our house, executed one agreement that after attaining majority, marriage will be solemnized. Before that, Lordship, they abused my brother, for which he committed suicide, Lordship. Accordingly, I filed a case against their family members. And when I filed a case, there were, some of them were arrested. And after that, they lost the present case implicating that victim was abused by the present petitioner. Whereas, Lordship, she was having affair with my brother, Lordship,
Yes, my lord.
a deed of agreement is also there.
Who's committed
My lord,
suicide?
My brother committed suicide
Another brother.
because he was abused by the family members of the guy.
When the family had come to your place?
Yes.
During that time?
During that time. So in that connection, I filed a case, our family members filed a case. In that case, family members of the girl were arrested.
This is
And
an
after-
this is
After
an
that, this present case was lost.
a kind of a
That while
revenge.
returning the girl, after executing the agreement, she was raped by the present petitioner. That is the allegation.
Acha, whatever, the
Hi,
charge sheet is fine.
Here, my lord, actually, he wants bail in case number 40.
Yes.
40, my lord, the case that is not received.
Kajalgaon Police Station 40
Yes, 14 mile case that is not received.
and
Charge
charge
sheet
sheet not
filed
filed.
in case of case number 35.
35 is
The
the
case
which I
that was
filed.
lodged against him
No, 35 is
Oh.
the case lost by,
by you.
in that case, record may be called for,
And,
and in our case, that case diary,
Yes.
where I am seeking bail, in that case diary may be called for.
Okay, then case diary you bring
Ma'am.
in regard, with regard to 40.
Yes. ma'am.
And in the, I mean, both the case diaries were called.
Yes, earlier.
All for the case diaries, okay, both.
Yes, madam. Good.
So, okay.
Now
Heard
registry
Mr.
may
A. Ahmed, learned counsel for the petitioner, and Mr. Bonkim Sharma, learned APP for the state. By the earlier order dated 26/5/2026, case diaries of both the cases, one filed by the petitioner and one filed by the opposite party, were called. That is Kajalgaon PS case number 40 of 2026 and Kajalgaon PS case number 35 of 2026. Mr. B. Sharma, learned APP, however, submits that with respect to Kajalgaon PS case number 35 of 2026, charge sheet is submitted. And in respect of Kajalgaon PS case number 40 of 26, the case diary he is yet to receive. As such, he has prayed for some time to place the case diary in connection with the said case. In view of the same, the learned APP is directed to place the case diary of the aforesaid case, that is Kajalgaon PS case number 40 of 2026 on the next date fixed. You want
Registry may be directed to procure that record, Lordship, that is PRC number.
that also you want?
Lordship, that is all.
Further, the registry is directed to, the registry is directed to call the scanned copy of the trial court records
Of PRC case
in
number.
connection with Kajalgaon PS case number 35 of 2026,
Now it is Lordship PRC number 62 of 2020.
registered now as PRC case number
62 of 2026,
62 of 2026,
pending before JMFC Srirang.
pending before JMFC Chirang. List this matter again on
Uh,
24 ma'am.
24th of
Next
June.
week on, Lordship, if possible, because I will have to take step, because due to oversight, I could not take step on response.
19th and then 19th.
19th.
19th?
Right.
19th.
That, Lordship, regarding service, observation may be there.
Service, why?
No, because I have to take step.
POCSO?
POCSO, madam.
Oh, POCSO is there. That is not ordered by last order.
Last order, but due to oversight, I could not take step.
Further, the learned counsel for petitioner submits that he should be allowed 2 days' time to take steps for service of notice upon respondent number 2. Prayer is allowed. Prayer. Hetu agot di diba list on so and so. You take steps through PP office. Ah, yes. Now, what happened in an earlier case? They took it by speed post. As per notice, as per the
Evaluation.
practice directions. As per the practice directions, to take steps will they go? Yes, yes.
May I please, Lordship?
23,
24.
24, yes. Yes, Mr. Yeah,
Lordship.
Mr.
Lordship, it's-
Case diary is there.
Yes.
matter pertains to cyber crime basically, Lordship. The-
Cyber crime,
Yes, Lordship,
very bad.
as per section, Lordship.
Worse than murders and all.
Yes,
Then,
Lordship, upon secret information, the
where is the FIR?
FIR is page 11,
Page?
11, Lordship.
What is the Ejahar? Where is the
Relevant
Ejahar?
portion is 17, Lordship. Lordship, may I read the FIR?
No, I'll read it myself. It's okay. What is the name of the petitioner?
No,
Sajidu.
no, my name is not there, Lordship.
Okay, I will read it. Your name is not there amongst these 8.
No, Lordship.
So,
Lordship, police have registered under section 61S 318,
Hmm.
162, 3363,
hmm.
66C.
Yes, I've seen this. Huh.
Lordship, the offense, the punishment for this offense is below 7 years or up to 7 years, Lordship.
Hmm.
Then Lordship, the
Notice.
case has to be seen differently, Lordship.
Notice.
Yes, Lordship. Notice has to be there. What the police is doing, Lordship, without serving notice, despite of the fact that the offense is, the punishment for this offense is below 7 years, the police is trying to arrest, Lordship. So that is the Lordship. But
I mean, when did your name figure?
my name figure, Lordship, what happened, Lordship? On 14, Lordship, all the 8 accused person from the particular call center were arrested, Lordship. And later on 23, my brother was arrested, Lordship. And as per forwarding report that maybe.
So your brother is amongst the accused persons.
Yes, Lordship, but not in the among the 8 person, Lordship. He
Acha.
was arrested differently, Lordship. And as per the forwarding report, Lordship, police says that my brother told my name that I am along with my brother doing this all.
Oh,
cyber
your
crime.
brother implicated you.
Yes, Lordship.
Acha, your brother is Rafiqul Haq.
Lordship. And the fact that, Lordship, all the 8 parties.
During his accused, we disclosed that he and his brother Sajidul are main facilitators of the offense. SIM cards and so and so. Okay, okay. Your brother implicated you,
Yes,
right?
Lordship, that has been written by the investigation authority. Anyway, Lordship.
Your brother did not do.
No, Lordship. By my brother. Yes,
So much of it. Acha, there is a justification for no notice.
Yes.
What is that? How
Lordship,
can there be any justification? There was a reasonable apprehension that the accused, if served with the notice, would destroy concealed material evidence. That cannot be a cause.
No, for the arrested person, he is not the arrested person.
then also, Lordship.
No.
No, notice has to be given. Then if notice not given, where is the apprehension, Malan?
Hmm.
Now, Malan, modus operandi of this case is
Why
that,
are you apprehending, but?
Apprehending because in the forwarding, my name is come, Lordship. Police is coming every day, Lordship. That is my apprehension, Lordship.
Hmm.
Regarding the police has to serve notice, Lordship, as the offense is below 7 years, Lordship. That has been dictated by the Honorable Supreme Court, Lordship.
That is okay.
That is-
Not Supreme Court, the statute says.
So, Lordship, what happened, Lordship, as per FIR, Lordship, the place, that is the Alamin Nagar, Lordship, as pointed out by the secret source, Lordship, that is owned by one Lutfur Rahman. So Lutfur Rahman, Lordship. And as per the FIR, Lordship, the entire call center is being carried out at that particular place, Lordship. But in the forwarding level, police is saying that the call center is running in their adjacent to my tiles and sanitary shop, Lordship. There is a contradiction, Lordship.
No, it can be near your shop.
No, Malan. When secret information received, for the first instance, Malan, so his brother were arrested subsequently, not on the first day. First day, when got the secret information that one call center is going on, Malan, this 8 persons found, Malan, they were arrested. Modus operandi of the case is that, Malan, call center is running. They called any people, pick up any phone number, that you are a lucky person.
Hmm.
We are from
This is what happens, huh?
Bajaj Finance. You are lucky enough, and a loan will be sanctioned from 50,000 to 5 lakh. They say any amount, 50,000 to 5 lakh,
Hmm.
and they provided the documents,
Hmm.
Aadhaar card and all this. After providing the document, they said that to all victims, there are statement of victim persons, Malat, 183 statement also there. Same amount to all persons, Malat, 2,750. This is the amount for
Insurance.
for no, not security, for insurance.
Insurance.
For insurance. That amount has to be paid. After paying that amount, they don't pick up the call. And this is going on from 3 months. Now, first instance started from the house of the petitioner and his brother.
Hmm.
Subsequently, they extended to this new place. But police went to the new place first and got rendered this 8%.
That information is not there in the FIR.
No, FIR not there.
That
FIR,
they
got
actually
the
got-
information to subsequently during the investigation, they got that another call center is running in the house of the petitioner also. And from there, Malad, his brother was arrested. Malad. Now he is in Bangalore. as per the statement of the brother, he is in Bangalore, and he is also doing same thing. He and the brother, these are the person, these are the two person who provided these all SIM cards and all this. They call the customers with different phone numbers. They are changing the phone numbers so that they cannot be traced out. So all these SIM cards and all this supplied by the petitioner and his brother.
That
Make-
is what is said by the brother Sajidul.
Yes.
Sajidul Rafiqul.
Rafiqul.
Rafiqul said that he and his brother main facilitators who provide SIM cards, mobile phones,
No,
and
other-
their residents
and the other
were
persons also,
operating fake.
and the other persons also who were arrested. These 8 persons
Hmm.
first arrested on 14/4.
But yes, but of course, very bad in occurrence. But then, fact remains that they had raided one house and they got 8 persons.
8%.
You said that after that they again got the information, or before that they got the information that
No,
it was
after
done
that-
in the
after-
house of the.
No, that is another.
Hmm.
First, there is a when ready, there are 8% arrested at the house of Lutfur Rahman. Subsequently, during investigation, police came to know that another call center is also running in the house of the petitioner and the brother, and they are the main person who provided the SIM cards and all this.
Now, it is the statement of Rafiqul.
Yes, statement of the Rafiqul and the statement of the other co-accused also.
Then
And
after
this
that,
still under
Rafiqul was arrested, right?
Yes, Rafiqul was arrested.
Rafiqul was arrested.
Yes, on I think 24/6 or.
But how can I stop the petitioner from getting bail? Because statements are only given by his brother. Right.
But investigation stays in. Investigation will progress by the statement of the co-accused also.
Hmm.
After the investigation, how police will come to know?
Acha, where are these? Oh, you have saying from the case diary.
Yes,
right?
Daddy. And the statements of the victims, they all said that 2,700, thousands of people there from last.
And other co-accused have also named him. Sajidul.
Yes. Other 8 persons, all they stated that Rafiqul and the Sajidul, they are the main person who provided the SIM card and all this. At this stage, other person got arrested, he is absconding, his custodial interrogation very much necessary. And
It's like cheating the public. Heard, Mr.
Lordship, Lordship, may I submit, Lordship?
Hmm.
Lordship, though this is the statement of the co-accused only, Lordship. My brother was arrested, who has been
No,
released
police
from-
may not be
state-
convicted on the statement of the
Okay.
co-accused, but
That
in
is
the
the
investigation
conviction
stage,
stage. Like in the other case, there were other facts along with the co-accused statement. In those cases, okay, I can consider.
Lordship, Lordship, may I submit, Lordship. Lordship, they are saying that the call center also was running at my residence, Lordship. My brother was arrested. What has been recovered from my brother, Lordship? Nothing has been recovered. No mobile phone, nothing, no document related to the cyber crime, Lordship.
Okay, no, nothing. By that time, he had hidden things, or you not know. But then everyone has taken your name, you and your brother as the key
Lordship,
members.
I will appear before the IO, Lordship, whenever call for, Lordship. Otherwise, this is the.
Now again, you are in Bangalore.
No, Lordship,
then-
Lordship, no, he's not in Bangalore, Lordship. He's hiding, because Lordship, due to fear of arrest, Lordship. So he will appear, Lordship. Nothing have been recovered from my brother, Lordship. Everything is there, but he will face trial, Lordship. Everything will.
Now the problem is whether you will appear before the IO.
Yes, Lordship, definitely.
Unless you are
Any
arrested.
condition, Lordship, any condition, Lordship may put, Lordship. He will appear before the IO, Lordship. No one, there is no name.
In other crimes, okay, but this is too cheating the entire
Lordship,
public.
I admit, Lordship, but that the
And the educated people, they do not get into that
these are all
conspiracy.
play
These are
person,
all small
4%.
young boys and working in somebody's places who get involved.
Lordship,
And you cheat those people.
Lordship, what happened, Lordship, the call center, purported call center, they are using some mobile phones and keypad, everything have been seized, Lordship. No, there is no, another offense will be committed, Lordship. So everything have been seized, Lordship, from the all 8 parties.
No, now he will not do is a different thing. He has already taken money. And there is no,
Lordship,
At
include
this
any
stage, my lord,
promotional lordship.
at this stage of investigation still going on, my lord, at this stage, my lord, may not be an analysis of all documents, my lord, of these electronic devices, all is still going on. It will take some time, my lord.
Lordship, all the, what investigation lordship is doing.
to appear within 10 days, and if not, then the bail order will be,
Yes, Lord.
will become null and void.
He will appear, my lord, definitely. Appearance, my lord, after getting the interim bail, my lord, he will definitely appear. But it doesn't help the investigation, my lord. Investigation, my lord, for his custodial intervention is very much necessary, my lord.
Lordship,
Okay,
obviously,
heard, Mister. What is your name?
R. Islam.
R. Islam.
Hmm?
R. Islam, learned counsel for the petitioner, and Mr. K.K. Parasha, learned APP for the state. By this application, the petitioner has prayed for bail in connection with Borpeta Road, PS case number. Pre-arrest bail, huh? Pre-arrest bail. In connection, Borpeta Road, PS case number 32 of 2026, registered under the various sections of law, including the offenses under the Information Technology Act 2000. The FIR sections kita likhi dibo paro. The FIR dated 14/4/2026 reveals 14/4/2026 reveals that on a reliable secret information, the police personnel raided a house owned by one Latfor Rahman and found 8 persons in the said house. And it was also found that those accused persons were involved in cybercrime activities. During the search, the accused persons, 8 in numbers, were arrested, and incriminating materials were recovered from their joint possession, indicating their involvement in cyber fraud activities. The police interrogated the accused persons, and it was revealed in the said interrogation that they were involved in cheating by impersonating themselves as employees of Bajaj Finance and they offered loans to the unsuspecting customers. And after they take the payments from the customers in the name of insurance, they don't make any further contacts with them. The learned counsel for the petitioner submits that petitioner was not found amongst the 8 accused persons involved in cybercrime in the said house, and that subsequently his name surfaced on the statement made by his brother, namely Rafiqul Haq, who stated to have revealed before the police personnel that he and his brother, that is the petitioner, are the main facilitators of the offense. And it is they who provided SIM cards, mobile phones, etc., and was operating a fake call center. The learned counsel further submits that the police personnel have visited his house and that although the offense mentioned in the FIR entails less than 7 years of, entails 7 years and less than, entails a punishment for a term of maximum 7 years, the petitioner should have been served with a notice under section 35(3) of BNSS 2023, and that the same has not been done. On the other hand, Mr. K.K. Parashar, learned.
My lord, just one line I will add, my lord. Firstly, my lord, the money paid by the customers deposited in the account of Sajidul. This is one aspect, my lord, stated by the 7 persons, my lord. And, my lord, yes, an analysis of the mobile phone and his bank account is still pending, my lord, because he is not yet arrested. My lord, these two are the grounds, my lord.
Mr. K.K. Parashar, learned counsel for this state submits that the case diary revealed that that the information was that the first information was received in respect of running a call center in the house of said Lutfur Rahman, and on raiding the said house, 8 accused persons were arrested, having found involved in cybercrime, and that thereafter another information was received that a fake call center was operated upon also in the house of the petitioner. And on raiding the same, the petitioner's brother was arrested, who had revealed that he and the petitioner are involved in the offense. He also submitted that the co-accused who were arrested in pursuant to the first information had also revealed that the petitioner, along with his brother, are the main facilitators of the crime, and that money collected from the customers are deposited in the bank account of the petitioner. Para. Upon consideration of the submissions made by the learned counsels, and mainly on the ground that all the victims, including, all the accused persons, including the brother of the petitioner, had implicated the petitioner, who is stated to be the main accused person, and the offense, and seeing the offense of cheating the public, innocent public, this court does not deem it fit to enlarge the petitioner on bail at this stage. Petition is disposed of. No brother will implicate his own brother. There is something. Yes.
My lord, here, my lord, report regarding pending of the register of any case, my lord. I'm sorry, my lord, report today is not received, my lord.
Acha. Whether any case is registered.
Registered or not, my lord.
Police is searching you.
Next week, my lord, any that, my lord, I'll. Wednesday.
I heard Mr. A.T. Sarkar, learned counsel for the petitioner, and K.K. Parashar for the state. Mr. Parashar submits that he was directed to get the information as to whether any FIR is registered. Any case is registered against the petitioners, namely Purna Rabha and Jishing Rabha. However, when the matter is called up today, the learned APP seeks further time to get the instruction. Accordingly, list this matter on 17th of June 2026 for the necessary instructions. Yes, Mr. Azad.
My lord, very resolution.
Hmm.
My lord,
Yes, there is there, Asad.
There is,
my lord. PRS bail application, my lord, offense under section 318 subsection 4 seating, my lord. 319 subsection 2 seating by personation. 316 subsection 2 criminal piece of trust,
Hmm.
my lord. Now, my lord, kindly see the page.
FIR 14,
My lord.
FIR 14,
Yes, my lord, 14.
My lord, before starting,
cybercrime again.
before starting, my lord, I have already, my lord, the petitioner number 1.
Oh, my lord, I forgot to submit that.
Okay,
Petitioner
let's
number,
say what you wanted to say.
he's already arrested, petitioner number 1, yes.
Acha.
Forgot to submit that. I have
Ah.
to submit at first in that one. Yes, my lord.
You
And,
not
now,
have said.
petitioner number 2 is here, my lord.
Petition number 2 is yet to be arrested.
Yes, my lord.
Hmm.
Yes.
So this is cybercrime or what?
My lord, linguist of the affair, my lord, said that one Masood Jindul Ahmed, who has arrested accused,
Betting.
involved in the cyber crime, surrounding area of the Kolkata police station, and on the basis of secret information, police conducted search at the house of Masood Jindul and found some debit cards, credit cards.
Hmm.
Subsequently, from his, he is a mobile shop owner. From his mobile shop, numbers of mobile number handset, brand new handset are seized. And then subsequently again, another co-accused, Raju Islam, along with this earlier arrested accused Masood Jinnal, visited the house of co-accused Raju. And there also found some credit card, debit cards, and he has also mobile shop. And from his mobile, brand new numbers of mobile has been seized. My lord.
Okay, I'll read the FIR. Read.
My lord, page 14.
You are Sanidul.
I am, yes, Sanidul. Long affair, my lord, I'd like to read out relevant part out only.
No, long FIR means these Caesar things are not read with.
Yes. Readable content is short, my lord.
Hmm.
Now, my lord, mobile.
Once I have not finished reading.
Yes.
Okay, so Raju and this one,
Masood Jinnal.
Masood.
My lord.
Raju and Masood Jinul Ahmed.
My lord. Now,
How-
present petitioner is Sanidul Islam, my lord.
Oh, the names of other suspected
Yes.
associates involved are as follows. So Sanidul is 4.
My lord.
Hmm.
Now, in support of my case, my lord, I want to submit at first, my lord. See, my lord, FIR has been lost on the basis of some secret information. And on the basis of secret information, police conducted search two houses,
Hmm.
Raju's house and Masood's house.
Hmm.
But police can also, if accused Sanidul have seriously
can
involved
also
with
search
this case,
his place.
yes, his house can also search.
Hmm.
But police not search his house. Now, my lord, from that aspects, we can assume, my lord, probably involvement of present petitioner is not like that other two, my lord. That is my submission
Hmm.
at first. Now, my lord, 318.4, sitting, my lord. Exactly language of the sitting in our acts, what says, my lord.
Hmm.
Subject to
What are these other documents? Your rejection by the law court.
No, my
This
lord.
is AB or BA?
This is AB.
No, AB.
AB. My lord.
So-
Other documents, arrested accused, rejection of.
Oh,
Masood
Masood.
Jindal, yes.
Bail granted to Masood.
No, my lord, his bail is pending.
So what do you want to show from the definition of cheating?
My lord, whoever cheats and thereby dishonestly induces the person received to deliver any property to any person or to make, alter or destroy the whole or any part of valuable security or anything which is signed or sealed and which is capable of being
converted into valuable security shall be punished with imprisonment either.
So you had cheated, you
Well,
had,
Yes, now what I want to submit, my lord, whether in this case, any individual victim is there or not. In
victims
form of
is
question.
there, that will be found out.
But-
But initially it was from the victims only he got the information.
Yes.
My lord.
So it is
Now-
not a case that victims are not named, so no victims.
No, my lord. In this case, I want to submit, it's a not case of, my lord, cyber, because, my lord, cyber offenses are generally committed through electronic mode. IT Act is not
Hmm.
here.
Hmm.
And, my lord, not a case of cheating.
Hmm.
And, yeah, by this, these four FINM accused persons, my lord, not committed any cheat with any individuals, but secret information. There is a organized crime by FINM accused persons, cyber related.
Hmm.
But no, till CD will reveal everything, my lord. Till moment, my lord, not an individual victim is here in this case, and case lost by police person, my lord. Now, my lord, on the other hand, my lord, why the present petition?
Debit card, credit card,
Yes.
Yes.
file,
This
then
is says from the Raju and Masood.
checkbooks, SBI,
Yes.
empty white cards.
Now,
It's not one or two items, so many.
so many, my lord.
Okay, you can say one thing that he was stated by some co-accused, his name was given by
Yes,
some
yes.
co-accused and all. But then this is only investigation stage.
My lord.
In
Now,
the conviction stage, it will be seen.
Mm.
But here, names of other involved in the said are as follows. On what basis they have got these names, we do not know.
My lord, subsequently, section 14 of the Assam Gaming Betting Act added here. Now, my lord, case maybe, my lord, Assam Gaming Betting Act,
Hmm.
maybe on that part, my lord, but cheating is not here, absolutely, my lord. And criminal breach of trust also not here, my lord. And cyber IT Act is totally silent, my lord. And I am, on the basis of secret information, police conducted main 2 accused house, and from where everything has been seized. And police can also search conduct in my house also, if something like information like other 2 accused is.
Okay, let me
incorrect.
hear. What do you say, Mr. Sharma?
My lord, it is an organized crime, my lord. And my lord, investigation is on, my lord. My
Mm.
lord, in the meantime, my lord, his house also may be searched, my lord.
Mm.
Because, my lord, it is an act not done by, my lord, 1 or 2 person, my lord.
Mm.
It is, my lord has found, my lord, that 74 numbers of credit card and 84 numbers of, my lord, mobile handset
Mm.
recovered from one place. And, my lord, there are, and my lord, from the statement of the co-accused, my lord, they have named the present petitioner also.
It is also not clear whether it is from co-accused. They just said that they are involved.
Yes, my lord.
But
So,
no,
my lord,
my lord,
it is,
it
now,
is-
my lord, all these, my lord, electronic devices are, my lord, verified. My lord, that will come, my lord. It is a
But it is-
investigation stage, my lord.
My lord, it is clear from the FIR, my lord, particularly says from the 2 accused. And my lord, numbers wise, it is classified in the FIR, my lord.
During investigation, his house was not searched.
My lord, till my lord, not search, but my lord, all it, because my lord, huge number of electronics, my lord, these are, my lord,
Those were found.
they are being
because
verified.
Other two.
Other 2 accused, my lord.
Yes,
Any
and their
condition, I will,
statement, everything is there, my lord.
Otherwise,
heard
once
Mr.
And my lord, bank accounts,
Heard Mr. A.K. Azad, learned counsel for the petitioner, and Mr. Bankim Sharma, learned APP for the state by this application. And the,
one respectful submission, my lord, that from the CD, kindly, my lord, whether any individual victim from the CD, my lord, kindly peruse on that part, whether any individual victim is there or not, my lord, regarding sitting and
any victim there, Mr. Sharma?
kindly observe that part.
oh, my lord, that part, my lord, it is still in investigation stage, my lord.
Okay,
So,
don't
my
worry.
lord, kindly have a look, my lord. There are these persons, my lord, they are from their bank accounts, my lord.
Hmm.
These, my lord, from my lord, one Rajendra Bakur, 2,000 rupees. Then, my lord, from Jiggesh Kumar Shah, it is 27,000 rupees. There are lots of persons' money, my lord,
But not by him, by the entire group.
entire group. Entire
And
group.
my involvement is, my lord, nothing.
Okay, yes,
And
have
I am
Mr.
only, why I am apprehending, made accused in this case, my lord.
It's
I have-
okay, I'm not rejecting. Why are you apprehending? I mean, he's not allowing me to dictate the order.
My lord.
Okay, the petitioners, কি করলো? By this application, the petitioners have
The
prayed
long
for
list.
bail, has prayed for bail in connection with Colgasia PS case number, পারিবা জানো? Case short করা, case number 46 of 2026, registered under section 61 subsection 2, 318 subsection 4, 319 subsection 2, 316 subsection 2, 3 subsection 5 of BNS, read with section 14 of the Assam Gaming and Betting Act, BETTING. At the very outset, it was stated that amongst the two petitioners, petitioner number 1 was already, petitioner number 1 has already been arrested, and as such, this application will have to be considered only in respect of petitioner number 2, namely Sanidul Islam. The FIR dated 7/5/2026 reveals that on a secret information, the police personnel raided house of one Masood Jinnul, ZINNUL, Zinnul Ahmed, and found a number of incriminating materials / articles from his house, and it was deduced that cybercrime activities are being carried on in his house. The shop of said Masood Ahmed was also searched, and a number of suspected articles were recovered. And that thereafter, the police proceeded to the house of one Raju Ahmed, and there also search was conducted. A number of incriminating articles were found. Full stop. In the said FIR, it is further stipulated by the police personnel that other associates are also involved in the said cybercrime. And there, the police had stated 5 names, and amongst them, petitioner is one of them. The learned counsel for the petitioner submits that, like the house of the other 2 co-accused were searched, the house of the petitioner could also be searched. However, the same was not done, and simply the name of the petitioner was stated in the FIR. He further stated that there is nothing in the first information report that the offense is relatable to cybercrime activities, although registration is done under few of the sections. Under registration is done under offenses of cybercrime. On the other hand, Mr. B. Sharma submits that on perusal of the case diary, that number of articles incriminating in nature were found in the house of the co-accused. And since the cybercrime is an organized activity, 2 persons cannot continue the same, and there will be other associates. And petitioner was found to be one of such associate. He had also stated that money was being collected from the victims in pursuance to the said criminal activities. On consideration of the submissions made by the parties, more so, consideration made by parties, and also due to the fact that the informant had not revealed the source of information as to how they found out the name of the petitioner as one of the associate involved in the cybercrime, and without there being any substantiating materials showing his involvement, this court finds it fit to enlarge the petitioner on pre-arrest bail on furnishing of a bail bond of rupees 20,000 with non-local satisfaction of arresting authority. Huh? Under the following condition, he will appear within 10 days. Petition is disposed of.
I'm deeply obliged.
It's okay. Yes. Notice to the informant.
My lord, we till now
Pokko.
have received, my lord, that is the information, my.
Can you fix the matter on Monday?
Okay, and you have not taken steps.
We
You
have
have
taken these
taken.
steps, my lord.
Okay. Heard Mr.
B. Borgo, my lord.
B. Borgohain, learned counsel for the petitioner, and Mr. K. Bosher, learned APP for the state. The office note reflects that steps for service of notice has been taken, but service service is not reflected to have been complete. Service of notice upon respond number 2 is not stated to have been complete. Right? As such, this court finds it fit to await for some more time as regards the service of notice. As you know, records are received. List this matter on
On Monday, lordship.
Monday is too early. List this matter on 19th, Friday.
My senior people will take instruction whether the service.
Yes, my
Okay.
lord, we will take instruction.
তার আগতে দিয়া, Mr. K. Bosher, learned APP, is directed to take instruction as to whether the service is effected upon respondent number 2. It will deliver. List this matter on 17th of June.
Must be.
মই ভাবিছিলো এইখিনি শেষ, মই এডমিশ্যন খিনি পাহৰিলো। বেল হিয়াৰিং আৰু এৰিট নাই ন? Good. Yes, revision,
Yes, madam.
item number 1, 2.
So the trial court record has been received. I think matter may be hard, madam, for final disposal, madam, the hearing.
It will take some time, right?
Yes, madam.
Okay, we will
After
fix
vacation, they may fix, madam, after.
Short date may be given, my lord. It's a old matter, more than 6 pounds case. More than
Why
10
don't you
years.
enter into some agreement? Pay him. Oh, you have to pay him.
No,
Madam,
he has to pay.
You.
yes,
pay him.
madam, for making an appeal, I have already paid 25% or 50%.
That too you have to under
Yes,
the
madam.
act.
It's a content finding.
Matter will fix for hearing, madam, after vacation.
Mr. H. Islam.
B Sinha.
B. Sinha. Yes. Mr. B. Sinha, learned counsel for the petitioner, heard Mr. B. Sinha and Mr.
Okay, boss.
L.K. Bora, learned counsel for the respondent. As agreed to by both the parties, list this matter for final disposal on 28th of July, Monday,
Yes.
no, Tuesday,
Yes,
21st of July.
I think matter may be admitted, madam, because after admitting there for hearing, madam, 26.
What admission now? Number of days number of months have elapsed. It's okay for final disposal.
Admission.
You are the only two parties, no other.
But because the negotiate NI Act.
So it's final disposal on 16th of, no, what did I say? 21st of July.
He took money for marrying her son And
No, no, whether it is maintainable or not, there is a two things, my lord.
Acha,
The ground I have taken, my lord, that one. Whether the petition is maintainable. huh?
acha.
let's say, but I would
21.
hear-
21.
Tuesday.
Tuesday.
Mm,
Obligation.
Yes, petition. Hmm.
Lordship, the petition before Lordship, a SLA order passed by the learned JMC Lordship, whereby initially the maintenance was rejected.
Hmm.
Thereafter, the respondent had preferred a revision before the receiving signatures, and that was allowed. And based on that, some quantum has been granted.
Hmm.
And against that order, the petitioner approached this honorable court. My referral teacher has also received Lordship. If my friend like this also matter fixed for final hearing Lordship.
Okay, final hearing on
Final hearing,
some
but
the
you-
other day, not
but-
Friday at
Yes,
4:15.
yes, but
Okay.
let it come in admission column itself, otherwise
It will take some time because also the entire teacher has to be clear because
Hmm.
not necessarily entirely, it is a fact is clear.
Okay, Mr. Heard, Mr.
SN Krishna.
S.N. Krishnaturiya, learned counsel for the petitioner, and Mr. P.P. Dotto, learned counsel for the
And
sole respondent,
Sole respondent.
Respondent.
for the sole respondent. The learned counsels for both the parties have agreed that the matter be taken up for final disposal,
Next week.
not next week, after the vacation. After the vacation. Full stop. Accordingly, list this matter on 15th of July.
Lordship.
Interim order is there.
Yes, Lordship.
Interim order passed earlier shall continue until the next returnable date.
Right.
Yes, Mr. Saikia, what, which item we are waiting for? 34 orders. 34. Okay, 34 to yes. It okay. 6, none appears on call for the petitioner. AJ Atia, case records. Scan copies of trial court records are here. No, not in your matter. The other matter, Mr. Lee.
My lord, yes, my lord, in item number 6, my lord, TCR is available, my lord.
Acha. Appears? Yes, she is there. Okay, I'll take up Mr. Saikia's matter and after that I'll go to yours. Okay. Divide. Yes. What is this 34? This is orders, Mr. Saikia. Why has it come up? Scan copy of the trial court records. So that is received. No, even the records are not here. Service is not complete.
Yes, madam, that is why.
Oh, you are appearing?
Yes, your Lordship.
You are appearing for?
Respondent number 2, your
Oh, there, the service is complete, but records are not here.
Yes, Lord.
Okay, registry to give reminder?
My lordship is pleased.
Okay.
On my humble prayer that the proceeding may kindly be suspended because if the case was fixed for argument, we were not provided to the petition for was rejected that we made a prayer under section 311 that material witness should be summoned because my plot of land had been sold by my wife and the other was written by police officer.
Okay, we will fix it. When is your matter fixed there for argument?
Other argument has been fixed on what that? Argument?
Maybe your application was considered as a delaying tactics. Oh,
15
what?
June, my lord.
Huh?
15
Yes.
June.
15 June.
Yes, Lord.
15 June is coming Monday.
But that is why, my lord.
Your Lordship, we were not served with the copy of the petition also, your Lordship. We
You do
appear-
one thing. You make an application for adjournment on that day that the matter is pending before the High Court.
That last occasion also, the honorable court was pleased.
Huh.
That petitioner may pray before the trial court.
No,
for
yes.
adjournment of the case.
So
Same
this,
matter may be passed on.
okay. Heard Mr. R.C. Saikia, learned senior counsel assisted by Miss, what Saikia? Miss K. Saikia, learned counsel for the petitioner and Mr.
SK Chakma. your-
S.K. Chakma, learned counsel for the respondent number 2 and Mr. K. Busho for respondent number 1. Mr. Chakma appears for respondent number 2 and he submits that a copy of the petition has not been served upon him. As such, the learned counsel for the petitioner, Ms. K. Korobi Saikia, is directed to give a copy of the same to the learned counsel appearing for respondent number 2. Further, by the last order, the Now, further, by the earlier orders,
Just one.
the scanned copies of the trial court record were called. However, the office note reflects that the records have not been received. As such, it is directed that the registry may issue reminder for receipt of the same. It is also submitted by Mr. Saikia that the next date fixed before the trial court for argument is on 15th of June 2026. And that by this instant application, he has challenged the order rejecting his application filed under section 311 of the CRPC. In view of the said fact, the petitioner is directed to make a prayer before the trial court for adjournment on the next date,
Yes,
on the ground that the matter is pending before the High Court.
yes.
List this matter on, take a long date,
After vacation, Lordship.
list this matter on 16th of July,
Well,
2026. You
obliged.
take a long adjournment.
Obliged.
Deeply obliged.
Yes, Mr. Atia? I was in fact, I had in fact dictated none appears.
No, my lord, I was.
No, it's
input
okay. it's okay.
number-
I'll always withdraw that, that dictation.
My lord,
Yes,
scan copy of 2 cases, my lord.
I think it has been received. Scan copies are here.
Please, my lord, I'm.
Received.
To verify the scan copy.
Okay.
Or my lord, if possible, in my cost,
Uh-huh.
may I supply a photostat copy?
Of the trial court records.
Yes.
No, that is a thing not allowed. You have to just go and check the trial court records here. Okay. Heard Mr. Atia, Mr. A.J. Atia, learned counsel for the petitioner, and Mr. K. Busher, learned APP for the state. Mr. Atia submits that the matter may be taken for disposal after the vacation. The prayer is allowed. List this matter on 16th of July, 2026.
My lord, after 20, my lord.
Okay, list this matter on 23rd of July, 2026. 23rd of July, 2026. Okay.
Like,
Yes.
May I please, Your Lordship? Lordship, this criminal revision has been filed
Hmm.
to summon the investigating officer of the instant case as court witness to appear before the learned trial court. Why, Lordship? Firstly,
It is for the trial court to decide why you had given application
Yes,
was rejected.
Yes, it is against the impugn order passed by the learned trial court, wherein he has rejected
You can
my
always
prayer.
call for the prosecution witness. Why court witness?
Lordship, this investigating officer has not been made a witness to the instant case. He has been kept withheld. And mentionably, Lordship, this investigating officer arrested the petitioner and produced him before the learned magistrate after 3 days of his arrest. And what is the cause of this delay that has not been mentioned in the entire prosecution case record? And secondly, Lordship, in the arrest memo also, the investigating officer has signed as being the IO. Then why he has been withheld from the instant case, that is a matter to be ascertained. And most importantly, the PW6 of the instant
He is the one who submitted charge sheet.
no, charge sheet has been submitted by another IO who arrested the co-accused of this instant case. And that investigating officer is PW6 of the IO of this instant case. And that PW6, while depositing his part of evidence before the learned trial court, he introduced a complete new story against the petitioner. A complete new sets of allegation has been invented, has been put before the learned court, and that too, those set of allegations were never mentioned in the FIR forwarding or the charge sheet submitted. Lordship, may please.
Investigation of the case was done by that officer
Yes.
who was not called.
No, investigation has been done by PW6.
Okay.
Pavitra Deka.
So his role was to what extent? The one you wanted to bring?
He arrested me. He arrested the present petitioner. and he has been kept withheld.
But it's okay. Arrest was made, and after 3 days he was produced. The subsequent IO can also place those facts.
No, but he didn't disclose those facts. He was asked why I was
You get
arrested.
an opportunity by cross-examining him.
We had cross-examined already,
Mm.
and that is that I have annexed. Here.
Mm.
Now, my prayer is that because that PW6 has deposed a complete new sets of allegation against me.
It's okay. It is for him to say. It is for the court to find out. How can you stop somebody from saying anything?
Lordship, may please spread us to page number 45. This is an NDPS case, Lordship,
Hmm.
wherein some contraband were recovered from a vehicle which the prosecution alleged that it was driven by me.
Hmm.
But in page number 45, that is PW6,
Hmm.
he deposed a complete new different story.
No, but then why will I go into all this? I'll only go into the fact that why that
Yes.
police officer is not made a party.
Yes.
But it seems that he had only arrested. But investigation was done by PW6.
Yes.
And as you have seen in other cases also, the subsequent police officer,
Yes.
he places whatever the erstwhile police officer does.
Lordship, the PW6 stated that I fired bullet. I tried to fire bullet upon the petition, upon the police officer, and the police officer, in order to stop me, they fired a bullet upon my leg.
Mm.
And that is an allegation. That is a serious allegation at the fag end of the trial. Considering these set of allegation, what if I am being convicted that this person tried to elope by?
You have lot of opportunities. You cross-examine him. You give your own defense. Everything will be considered.
Yes, Lordship, in the cross-examination, it has been brought on record
Ah.
that, and also this PW, in his cross-examination, he deposed that he was the one who arrested the petitioner. As per the prosecution paper, he was not the one who arrested the petitioner.
You show it to him that you are not the person who arrested me.
Yes,
You have shown in the cross-examination.
Yes.
Then what else?
Then,
Do you think that this said police officer will come and I have arrested? He will also lie if it is if he will if you bring him in the court.
of allegation that has been leveled against me, if the learned trial court convict me only based on those set of allegation, then there will be a loophole upon our part, upon the part of the defense counsel, that we have not tried to our extent to prove our case beyond reasonable doubt.
No, that cannot be because you see, in that case, you will bring so many witnesses that will not suffice the issue. Here, you will cross-examine the police officer and you will show that this is not your signature in the arrest memo. So how can you say you demolish his statements?
The one I am praying to summon him as witness, he has signed the arrest memo as investigating officer.
Yes, you show it to PW6 that you are not the person who had arrested.
Yes, that has been shown.
And then
That has been.
then what prejudice it will be caused to you?
What if only based on those why was I detained for the 3 long days?
That the prosecution has to answer. Why the investigating officer or the police officer who had simply arrested you? The prosecution has to answer that. Why there was a delay in producing the petitioner?
And that is why I want to summon this person as witness to get the words from his mouth that he has illegally detained me for 3 days.
Words should not come from his mouth. It will be clear from the records that he was produced 3 days later. That
Yes.
would be sufficient. Why somebody has to say, oh, who will admit otherwise?
Lordship, the impugn order based
Where
on
is the impugn order? Rejecting your application?
page number 30. Page number 30, and it continues to page number 32.
Acha, I'm seeing. It's a recent order, but then still in the last finding, that ground was not reflected, that he had to show why the petitioner was not produced within that 24 hours time. Mr. Rebosha, what do you say on this?
Lordship, in the
My lord,
order.
then my lord, TCR, my lord, already received, we have to produce the CD, my lord. Because now, my lord, what is stated by my learned friend is regarding the facts. She stated that somebody arrested some police personnel, my lord. Thereafter, when my lord arrest is made, after that only, my lord, they, my lord, make a, my lord, report to the OC that someone is arrested, and OC thereafter, my lord, appoint an IO, my lord, investigating of the case. Need not necessarily, my lord, always be, my lord, when a, my lord, the offense is committed, my lord, the person who arrested, my lord, he will be appointed as a, my lord, that is the
That
IO,
is
my lord.
not contending. He is
But
saying
now,
he
my lord,
arrested.
that is, my lord, that the fact we have to find out, my lord. Now, my lord, only the point is that she stated that, my lord, at that point of time when, my lord, the arrest was made, my lord, some, my lord, there is the firing who took place, my lord, and he is a material evidence as because he arrested the same. What I understand that that is her submission. No.
Did not arrest the petitioner.
Then,
Somebody else arrested him.
my
And
lord,
he
what?
stated that he saw the firing. He was the one who present there. Why didn't he made it mention in the charge sheet? That is a question.
Acha, you give him as a defense witness.
Yes, my lord.
But
If, my lord,
You
it
give his
is
state
that,
court
my lord.
recall.
Yes, my lord.
but he is the arresting officer. He will obviously not support the defense case, Lordship. He's the officer, police officer. And Lordship, the impugn order wherein the learned trial court stated that the Suleiman Ali, whom I'm praying to summon, he is not the informant, nor IO, nor
Yes.
the witness.
Yes.
He is the IO as per prosecution, and it is very much evident. Lordship, yes.
He is not the IO. You yourself said respond number 6. The PW number 6 is the IO.
Add to page number 33. Page number 33. This is the arrest memo of the petitioner.
Suleiman Ali. He is the one who arrested.
Yes, in the last paras, investigating officer SI Suleiman Ali. He has signed this in IO, but he has been kept withheld. And the impugn order states that he is not even the IO.
He was initially the IO. Later on, it was changed to PW6 or what?
No, PW6 is a complete different person.
Who conducted the investigation of the case?
PW6 is one IO who arrested the co-accused of the petitioner of the instant case.
Who went to the place and taken the statement? Who did all this?
It is done by PW6.
So PW6 is the IO. Where is PW6's statement?
In page number 40, continues from page number 44. Page number 44, Lordship may pass to point number 2, where he stated.
I arrested accused Biddut Dev, somebody else. Who is, what is your name?
Biddut Dev, but he did not arrested me. He did not arrested me. I was arrested by Suleiman Ali. And in the next para, he stated that in the next page, from the starting point, it reads as Biddut Dev pushed away UBC Atukal and tried to flee away by snatching arms Insas rifle. The accused person Biddut Dev fled away, asked to stop, but the accused person pointed the rifle towards our direction, finding no other option. I fired one round bullet on the right leg of the accused Biddut Dev. This is a serious.
Where is the cross-examination? I have not prepared. So, 7-7. I have prepared Caesar list. Where is that portion where you had pointed out that he was not the signatory to the arrest memo?
Lordship,
He was arrested on 30.
Point number 35. I have not seen any document as to what authority Suleiman Ali arrested Biddut Dev. Point number 32.
Yes, I've seen.
As per arrest memo, Biddut Dev, arresting officer Suleiman Ali and investigating officer Suleiman Ali. This case of mine has been investigated by Suleiman Ali. And the co-accused case has been investigated by Pavitra Deka, PW6.
And now the defense witnesses are examined.
Yes, everything is done. Examination of all the witnesses are done. The case is fixed for statement, recording statement of the witness, and and at that exact point, we filed a petition under
Case is fixed for 313. What?
311. So yes, 313, that's it.
Hmm.
And now an interim order has been passed to stay the case. And I filed this 311 petition before the learned tribunal where
Hmm.
it got rejected. And a revision has been referred before this. Point number
Okay.
54.
Heard Miss
Albany.
Huh?
Albany.
L. Banik, learned counsel for the petitioner, and Mr. K. Bosher, learned APP for the state. By this application filed under section 528.
Four 38.
438. 438 or 438 is the inherent power, right? Application under 438 of the BNSS 2023. The petitioner has challenged the order dated 7/3/2026 passed by the special judge Rongia, by which the application filed under section 311 of the CRPC, more specifically for calling one Suleiman Ali, who is stated to have arrested the petitioner, to be summoned as a witness in the case, that is NDPS case number 20 of 2022. The petitioner's case is that the trial against the said petitioner has been commenced, and the prosecution witnesses were examined, and the police officer who had investigated the case was also examined as PW number 6. However, the petitioner's case is that he was arrested not by PW number 6, but by one Suleiman Ali. Where is that arrest memo?
Page number.
One Suleiman Ali, as shown in the arrest memo,
Number 33.
as shown in the arrest memo dated 30/3/2022. And said Suleiman Ali is reflected as the investigating officer of the said case. The petitioner also submits that after his arrest on 30/3/2022, he was not produced before the magistrate. Within the
His arrest on 27/3/2022.
date and time is 33.
33 was produced. He was
This is
produced.
arrest memo.
Yes, it has been.
Date and
prepared-
time of
It
arrest.
has been prepared 3 days after he was detained. The case took place eventually on 27th of March.
What is the document to show?
FIR.
FIR.
FIR is there.
Show me the FIR.
FIR dated 27/3/2022.
Where is the FIR?
Page number 24. Page number 24, it is a reference has been made. After the reference, there is dated 27/3/2022 in the topmost part itself.
কি করলো?
This is on 23, 2023,
33.
33, 33.
30/3/2022 at 8:30 p.m. It is stated by the petitioner, it is further stated by the petitioner that the date and time shown in the arrest memo is incorrect. And to substantiate that, the learned counsel for the petitioners had placed the FIR in the instant case, that is lodged on 28/3/2022. And in the said FIR, it is written that on 27/3/2022, at about 7 p.m., a search was conducted and the petitioner, a search was conducted, a NACA checking was conducted. A NACA checking was conducted in the National Highway number 31. And after stopping the vehicle, after stopping the suspected vehicle, the petitioner who tried to run away from the said place was apprehended. Full stop. As such, the learned counsel submits that the petitioner was actually arrested or apprehended on 27/3/2022. And that after 3 days of his detention, he was placed before the learned magistrate. Full stop. Under section 57, right? What was that? 24 hours placing? Oh, 167. 167.
Yes.
Just take out that. Under section 57 or 167?
Yes.
57 is 57 is another under section আসলে CRPC দিলে ভালো ছিল
Yes, ma'am, 57 CRPC, ma'am.
57
Yes.
under section 57 of the CRPC 1973. What is now? This is 57. What is now?
My lord, now it is
Corresponding section of 57?
58, my lord, now. Section 58 of BNSS.
58. Okay. Under 57 of the CRPC or 58 of BNSS 2023, a police officer, it is provided that no police officer shall detain in custody a person arrested without warrant for a longer period without warrant, no police officer shall for a longer period than 24 hours, excluding the time necessary for the journey to the magistrate's court. It is as such seen that the arresting officer for us. The arrest memo placed by the petitioner shows that petitioner was arrested on 30/3/2022. Whereas the arrest was made on 27/3/2022. During the trial of the instant case, the PW number 6 stated that he was the investigating officer of the instant case and that he arrested the petitioner full stop. However, from the arrest memo, it becomes clear that one Suleiman Ali had arrested the accused person. But that is an arrest memo. And you are saying that he was produced on 33. Where is that to show apart from that 33 he was produced?
Lordship, it is not visible from here, but as per the record, the signature of the learned magistrate that dated back to 33.
Where is that? In the arrest memo.
Yes, in the arrest memo, it is not visible from my paper, but it may be in the childhood record.
The learned counsel for the petitioner submits that the petitioner was produced before the nearest magistrate on 33. That is after a period of 3 days from the said arrest. She also submits that PW number 6 was cross-examined on the said point, but PW 6 replied that it was he who arrested the petitioner and that the delay raised in respect of the petitioner that he was produced before the magistrate after a period of 3 days was negated. There seems to be a contradiction in the state. There seems to be a contradiction in the statement of PW number 6 and the arrest memo placed by the petitioner in this petition. The petitioner as such filed an application for calling of said Suleiman Ali as a witness in the instant case by taking recourse to section 311 of the CRPC, which was rejected by the learned court of Special Judge Rongia. Where was that order?
Page number 30.
Special Judge Rongia, as stated above. The learned court had rejected the said application mainly on the ground that said Suleiman Ali was neither the Caesar witness nor he was the informant, and that his testimony will not anyway is essential for the just decision of the case. However, while making the said observations, the learned court had given the finding that Suleiman Ali had arrested the petitioner. Section 311 of CRPC provides that any court may at any stage of inquiry, trial, or other proceeding can summon any person as witness, and the only requirement is to see whether it is required. The only requirement is to see whether calling of the said person would be in the just decision of the case. Since the case since it is the law of the land that petitioner is innocent till he is convicted, the petitioner should be given all opportunity to defend his case and to show his innocence. since there appears disputed facts as to who had arrested the petitioner and when was he arrested, this court finds it fit that said Suleiman Ali be called as a witness by the court of Special Judge Rongia for the just decision of the case. In view of the same, the order dated 7/3/2026 is set aside and the court is directed to allow Muhammad Suleiman Ali to be brought as a witness. Petition is disposed of. Okay, let a just decision be arrived because Suleiman Ali
My
arrested.
lord, in the
when
S
he
memo,
was-
it is very clear, my lord. The date is 30 and my lord, the GD is 27.
Mhm, 27.
FIR is 28. Again, he stated that he arrested the person and in the my lord cross-examination, he says that I don't,
I don't
there is the authority.
So
That
let's
should be
move on.
brought before this learned
Good.
court.
Okay, no more matters. It's already 5. What?
Yes, my lord.
Yesterday also it was there.
Yes, my lord.
You should have told me in the beginning.
No, I have, my lord, mentioned in the, yeah.
Oh, yes, you had mentioned.
My lord, small matter, my lord. Two
Okay,
persons
read
has
me
been,
36.
my lord, 2 persons has been convicted, my lord, by the
Uh-huh.
same judgment, my
Ah.
lord. One appeal filed by me, that is, my lord, item 36, and another appeal filed by another person, item 37, my lord.
Huh.
In item 37, my lord, this honorable court has granted bail, my lord. That is
Hmm.
IA number 613 of 2025.
Acha.
My lord, bail application is still pending. my lord.
Acha, okay. So what is the incarceration period?
My lord, 5 years, my lord. This is reflected in the order. It is
Acha.
also on record, my lord.
5 years. So he is inside for how many?
Well,
Okay.
reflected in the earlier order, my lord. It is reflected. Same judgment, my lord. He is
Oh,
one.
acha, acha. Abdul Hussain is a co-accused.
Yes, my lord, item 27.
37.
Sorry, 37.
Abdul Hussain.
My
And you are Imran Hussain.
My lord,
And Imran Hussain was also
my lord,
convicted.
case 3, my lord.
Same case.
Same case, my lord, same judgment.
Oh, acha. Then it's easy. Yes. Ayat likhiba, huh? Heard Mr. Sharma, R. Sharma,
Fine.
for learned counsel for the petitioner and Mr. K. Busher, learned APP for the state. By this application filed under section 430 of the BNSS 2023, the petitioner has prayed for suspension of the impugned judgment and order dated 23/2025,
My lord.
passed by the learned special judge Lokhimpur, North Lokhimpur, in special within bracket NDPS case number 10 of 2022, by which the applicant/appellant was convicted under section 21B within bracket B/29 of the NDPS Act and was sentenced to undergo RI for 5 years.
And my lord, 3 years is also there, my lord. Whether my lord, it is my lord
Concurrent.
concurrently or my lord, that is not clear, my lord, from the order. my lord.
Show me the judgment. It is concurrent or consecutive, Mr. Sharma?
My lord, it has not been, my lord, recorded. Page 42 in the IA, my lord.
So when it is not provided, then it is consecutive.
Yes, my lord.
That is the law.
Then my lord, it is 9 years, my lord.
Then it will be 9 years,
My
Mr.
lord,
Sharma.
8 years, my lord.
8 years.
8 years, my lord.
3, and it's not given, right?
Not given, my lord, in the order, my lord.
Page 42.
Perhaps the court forgot.
Yes, my lord. I am on the same footing, my lord.
Acha. 3, ki kolo? 5 years, no, 5 years, with fine and default stipulation under section 21B of NDBS Act. Full stop. The petitioner was also sentenced to undergo RI for 3 years with fine and default stipulation under section 29 of the NDPS Act. Full stop. In the said judgment and order, it is not reflected that the sentences would run concurrently. And as per the law laid down by the Honorable Supreme Court, when it is not provided by the court as to whether the sentences would run concurrently or consecutively, comma, the sentences would run consecutively. As such, the petitioner is sentenced to undergo RI for a period of 8 years.
And judgment is, my lord, delivered on, my lord, 28th of March 2025 only.
March
Then
20.
what happened?
So late in coming?
Not late, my lord, I have already.
He is inside now, 1.5 years.
Yes, my lord.
The learned counsel for the petitioner submits that the petitioner, after the said judgment and order was passed, that is on 23/2025, the applicant had surrendered
My lord.
and is inside the jail to serve out his sentence since the said date. And by now, he has completed 1 year, 1 year, 3 months,
3 months.
4, 5, 6, 1 year, 3 months of incarceration out of his total period of 8 years. You tell me some grounds of
Yes,
suspension.
my lord, that
Yeah.
is the, my lord, the influence judgment is, my lord, my lord, suffers, my lord, under section 50 and 52A, my lord.
Mm.
And my lord, there is a contradiction as regards the date, time, and my lord, period of incident, my lord. And so far, the, my lord, Caesar witness is concerned, my lord, they have not, my lord, seen the, my lord, incident, my lord, and while signing the, my lord, Caesar memo, it has not been read out, only they have put their signs. That is the, my lord, clearly stated in
So
the.
Caesar memo, what do you say? They did not put their signature.
No, they put their signatures, but they have not seen the, my lord, recovery part. That.
Learned counsel for the petitioner submits that during the investigation of the instant case, section 50 and 52A of the NDPS Act were not followed. And that further, there were many discrepancies regarding
These are witnesses.
the date and time of seizure.
Yes.
Date and time of seizure. And also that the petitioner had not seen what was written in the Caesar memo, and that he had simply put his signature.
And my lord, the recovery is not made from me, my lord. Recovery is, my lord, from A2. It is reflected in the judgment, my lord, para 30.
He also submits that recovery of the contrabands was not made from the petitioner.
A3.
Rather, it was recovered from accused number 2. And he was accused number 3.
My lord, I am it.
And he was accused number 3 in the said case. On the other hand, Mr. Bosho, K. Bosho, learned APP for the state, submits that procedures have been undertaken properly while investigating the case, and recovery was also made from the petitioner. Full stop. Para. On consideration of the submissions made by the counsels of both the parties, and in consideration of the fact of the case, as well as the fact that intermediate quantity was recovered in the instant case, and further due to the violation of certain provisions of NDPS Act, this court deems it fit to release the petitioner on bail, or this court deems it fit to suspend the sentence suspend the sentence, void judgment and order dated 23/2025, and the petitioner be released on bail. Or applicant diva, petitioner niba, petitioner ko se applicant diva. applicant be released on bail on furnishing of a bail bond of rupees 30,000 with 2 local sureties of the like amount to the satisfaction of the learned special judge, Lokhimpur, not Lokhimpur. Under the following conditions, no conditions, right? Issue that, no, it's okay. Petition is disposed of. Are at a ground likhi dibason. This court also considers the fact that the co-convict,
Yes.
namely Abdul Hussain, was also released on bail by suspending the sentence. Etu mazodi di diba. Petition is disposed of. Yes. No more, no more. 32.
Wednesday, 17.
32.
Yes, sir.
On the prayer made by the counsel appearing for the petitioner,
That's Islam.
list this matter on 17th of.
Lordship,
Service completed, Lordship.
I am for respondent number 2.
You have Mr.
Respondent number 2.
You have
Shahjahan Mia, A. Mishra.
Mr. A. Mishra appears for respondent number 2.
Lordship, in 38, your Lordship, this is the second day. Only notice needs to be issued at this.
Oh, yesterday you said
Yes, your Lord.
38.
Yes, your Lord.
This is a cancellation of bail.
Yes, your Lordship. Granted by your Lordship.
Listen, 38 today. This notice issue going. Heard Mr. A. Mishra, learned counsel for the petitioner,
For the applicant.
for the applicant,
Lordship.
and Mr. K. Bosher, learned APP for the state. By this application, the petitioner has prayed for cancellation of pre-arrest bail.
AB number.
This court has granted.
Yes, your Lord.
Where is that? Why do you want to cancel the bill? Where is that order?
Yes, your Lordship. The order is at page number 63, Lord.
Cancellation of the pre-arrest bail accorded to the petitioners
In AB.
in Gauripur PS case number. Oh, no. Pre-arrest bail accorded in connection with Gauripur PS case number.
234 of 2020.
Oh, no. Pre-arrest bail to the accorded to the petitioner by order dated.
27 to 2026.
Acha, where is that?
63, Lordship.
63. 6. In connection with Gauripur PS case number 234 of 2025, registered under section 61, subsection 2/103, subsection 1 of BNS 2023. Issue notice, returnable by 3 weeks. Petitioner to take steps for service of notice upon respondent number 1 and 2. Oh, no.
Two and
On respondent number
2 and 3.
2 and 3. 3 by speed post with AD or by usual process. Mr. K. Bosho appears for respondent number 1. List this matter after vacation. List this matter on 15th of July.
May I
I'm
please your-
thinking of it.
No more. Let me go. Yes, what matter? Tell me.
It is for order matter, item number 30. We have already taken steps, but it's awaited for the service report. Actually, we
30.
have taken several steps that if lordship permits, can an amicus curiae be
Acha, this
appointed?
is POXO.
NI matter.
NI matter.
It's a
We
private.
will hear without his presence if the service is complete. Amicus curiae is not required, right, Mr. Mishra?
We have taken several steps, but the service report is awaited.
Take
So we are
fresh
unable to
steps.
move.
District magistrate also, notice was issued, but it is not complete. By hand, can you serve him? By dusting?
I am not aware of it.
Try by hand, although it is not applicable, but try by hand. Heard, Miss?
N Kashyap.
N. Kashyap, learned counsel for the petitioner, and Mr. K. Bushra for the AP, for the state. Miss Kashyap submits that number of times steps were taken for service of notice upon respondent number 2, but the same could not be complete. And as such, prayer is made that she be allowed to take the service of, she be allowed to take the service of notice upon respond number 2 by dusty method, full stop. Although the same is not provided for in under the criminal jurisdiction, however, the same is allowed for the ends of justice. The petitioner, after service of notice by hand, may file an application on that behalf. List this matter on before,
After vacation,
list this matter on 14th of July,
much obliged.
2026. Ouch. Okay. Huh? So,